Joshua, you're good to go.
Thank you. Good afternoon. The Appellate Division First Department is now in session. We will now proceed with our virtual arguments. I'm going to ask that everyone please mute your microphones unless you are actually obviously speaking. People v. Senny Ellis.
Good afternoon. Benjamin Rutkenbecker on behalf of Senny Ellis.
Karen Schlossberg on behalf of the people. Good afternoon.
Good afternoon. Darahuna versus Perez, submitted. M. Children, submitted. Cone versus Appellant.
Good afternoon, Your Honor. Adam Swanson for the appellant, and Your Honor's breaking up a little bit. I apologize.
Cortellis versus New York City Department of Education, submitted. People v. Regional Herbin. Appellant.
Ariel Reed of the Center for Appellate Litigation for Mr. Herbin. Good afternoon, Your Honor.
Vincent Revelisi for the people of the state of New York. Good afternoon, Your Honor.
Good afternoon. People v. Jose Perez.
Good afternoon. Benjamin Weiner on behalf of appellant Mr. Perez.
Respondent.
Hi, sorry, I was muted. It's Michael Yetter for the people.
Thank you. Radio Drama versus K.
Gary Friedman for the appellant, Richard K.
Gary Sesser for respondent, Radio Drama Network.
HTRF Ventures versus Parastelius North.
Good afternoon, Your Honor. Michael Rogers from Wasserman, Grubin, and Rogers for appellant Permis de Lisa North America Corporation.
Good afternoon, Your Honor. Brent
Gurney
for HTRF.
I'm sorry, could you repeat that?
Yes, Your Honor. Brent Gurney for HTRF.
Thank you. I'm sorry, yes, there is another appellant.
Yes, I apologize. Ilya Feltrov for HTRF.
Thank you. Kopskov versus law firm of Sewell.
Good afternoon, Your Honor. Alex Kovkov, pro se plaintiff appellant.
Good afternoon, Your Honor. Kenneth McClellan, representing respondents Sewell and Valser-Bramium.
Thank you.
Thank you, Your Honor.
Monique J. versus Keith S.
Good afternoon, Your Honor. This is Shanice Hinkson from Simpson Thatcher and Bartlett for the respondent Monique J.
Thank you. People v. Christopher S. submitted. People v. Lauren Zuniga.
Good afternoon, Your Honor. Zoe Root from the Center for Appellate Litigation on behalf of Lauren Zuniga.
Good afternoon, Your Honor. Jonathan Cantarero for the people.
Rossman versus Windermere Owners.
Good afternoon, Your Honor. Richard Feldman for the appellants.
And yes, good afternoon, Your Honors. Mark Bogatin for the respondent, Arnold Rossman.
Gerard versus Barnes and Nobles, submitted. People v. Henry Webb, submitted. People v. Derek Smith.
Yes, good afternoon, Your Honor. Alma Gonzalez, Center for Appellate Litigation for Mr. Smith.
Good afternoon, Your Honor. This is Morgan Namian, and I'm here on behalf of the people, but I'm arguing under the supervision of ADA Nancy Killian, who is also here.
Thank you.
Good afternoon, Your Honor.
Ms. Killian?
Yes, I just said good afternoon. Thank you.
Thank you. Nicolone versus Marco Realty, submitted. Victor Media versus Go New York.
Good afternoon, Your Honor. Maurice Ross for appellant Go New York Tours, Inc.
Good afternoon, Your Honor. Brian Katz for the respondent, Vector Media.
Vetra Inc. versus 95 Madison, submitted. First case for argument, People v. Senny Ellis.
Good afternoon. Benjamin Rutkenbecker on behalf of Senny Ellis. Before I begin, I was granted 5 minutes. If I may reserve 1 minute for rebuttal.
Yes, and also please, as I forgot to state again, it is really important that you all mute your mics. Also, please avoid talking over the justices. This has been a traditional rule of this court. even more important when we're doing the virtual arguments. So please do not speak over the justices, and please keep your mics muted. So I'm sorry, yes, counsel, you wanted 4 and 1?
Yes, Your Honor.
Proceed.
Thank you. May it please the court. The court officer's instruction to the deliberating jury to listen to the 911 call rather than looking at the transcript requires reversal of Mr. Ellis's conviction. The court officer exceeded his ministerial duties by directing the jury to specific evidence while the court was absent during lunch.
Well, counsel, I actually had a question as to that, because in going through the record, it was really unclear as to what, if anything, was said by the court officer to the jurors. I don't believe that that was actually gone into by the judge, and I don't believe that that question was posed by the defense attorney. So how do we know, or what do we know exactly what was stated by the court officers to the jurors?
Yes, Your Honor. So I do agree that defense counsel did not probe this, but I disagree that the record isn't clear on this point. And the judge on page 145 is referring, when the judge references an instruction to listen to the 911 call made over lunch, the judge is referring to the conversations that the judge had with the court officer and what the court officer had relayed to the judge about the court officer's supervision of the jury while the court was absent during lunch. And furthermore, the jury note demonstrated confusion with the court's prior instruction because the jury only explicitly referenced the transcript. And so taken in context, the court is referencing an instruction made over lunch by the court officer. And even if Your Honors were to disagree that the record is clear here, at a minimum, there is ambiguity in the record, sufficient that the proper remedy would be a reconstruction hearing rather than dismissal. And
why is there that ambiguity in the record? If there is any ambiguity, would that not be due to the fact that this issue was not really preserved by further inquiry by the defense attorney?
So on the topic of preservation, Your Honor, this issue is one of the rare motive proceedings issues that the Court of Appeals has made clear cuts to the fairness of a trial and does not need to be preserved, and also harmless error is irrelevant to the merits. Again, if this court does find that the record is ambiguous, there at the very least is a strong suggestion here, because of the court's statements in context, that the court officer instructed the jury. And a reconstruction hearing is the proper vehicle to clarify the record and to answer this simple question as to whether an instruction was in fact given by the court officer. This is not a type of record and question that would need a detailed and new factual record to be developed. And the Court of Appeals, since the McLean case cited by the prosecution, has ordered reconstruction hearings in similar contexts in which, again...
If I may, please, Judge Mazzarelli, I have a question. Is there anything in the record to indicate that the court officer's statements related to anything other than the exhibits?
There is not, Your Honor. Although the court officer's instruction, as relayed by the judge, was an instruction to listen to the 911 call.
Counsel, let me stop you right there for 1 second. This is Judge Doring. How does that, what you just say, play out when the court advised the jury very early on that the rules of evidence, or that what governs is what's on the tape? This transcript is secondary evidence just to assist you. So the fact that during deliberations they asked for the 911 tape, the jury is actually following or listened to and heeded the judge's instruction, which is to listen to the 911 tape. Don't rely on the transcript. So at that moment, perhaps we don't have anything in the record here that says the court officer did anything other than just give them the tapes. They said they wanted the tapes. Here are the tapes. They're following exactly what the court told them to do. How does that play out then, based on what you just said?
Well, Justice Oing, so I agree that that is exactly what should have happened. The court officer did not need to instruct the jury here, but that is what the court states happened. What the court states that the court officer relayed to the court about its supervision of the jury over lunch. And the jury note did.
Counsel, your time is up. You can complete that on your rebuttal. People?
Thank you, Your Honor.
May it please the court, Karen Schlossberg for the people. The record is not clear. It's not even clear that the court officer said anything. What is clear from the record is that the notes came in. The note came in before the lunch break. The parties had an opportunity to read the note. The judge had just said before they adjourned the case that he wanted to discuss with the parties how they were going to handle the 911 tape. Presumably that conversation happened off the record. There's no indication. We don't know what happened because the defense was obviously part of formulating the response and then didn't object when the judge later recounted what had happened.
Well, here's the problem, counsel. Your adversary states that or argues that that is an ambiguity in the record. And because there's an ambiguity in the record, we cannot therefore make a determination, and therefore we should remand the matter. What do you say to that?
Well, the cases that my adversary put in his reply brief that say that there can be a reconstruction hearing in these situations, those were situations that are entirely different from this one. Those were cases where the record is not even clear if the court, those were jury note cases where something came up later after the trial was over where there was an indication that maybe there was a jury note that no one had seen during the trial, and so they needed to remand to find out what exactly had happened. Here we have a full record. The notes came in, the judge put on the record, the notes came in before the lunch break. The judge was clear for the record that the parties had the opportunity to review the notes. They obviously formulated a response together. The judge then, in compliance with ORAMA, read the notes, discussed them ahead of time. Then when the jury came in, discussed them again, talked about what happened. The defendant at no time objected to anything, didn't complain about any procedure. And the record makes it seem, when you read it, although I'm inferring this, it's not explicit, makes it seem that this is what the defendant wanted to happen. Whatever happened was what the defendant was asking for. In those circumstances, there's no reason. I mean, McLean is very clear. The defense has an obligation to make sure there is a record that allows review if they want to review it on appeal. And here, the defendant didn't do that.
Counselor, actually, to go into your point, I'm looking at my notes here. When the jury came back in, having already saw the 911 tapes provided by the court officer, the court says the court told the jurors that it had been informed, I guess gathered by the court officer, that you got to hear the 911 again and saw the video. So just from that statement alone, seems like it's just merely just a court officer. We can't tell in this record, but just based on what I have here, the court officer just provided the 911 tape in conformity with what the court has said earlier, saying you guys got to look at the 911 tape. Don't look at anything else, right?
In my brief, one of the things I said was that we don't know what happened. It's entirely possible that when the judge says, that they heard it with the instruction that they had to listen to it, that he's just referring back to the instruction he himself had given on the last trial day. It's also possible that when the defense attorney and the prosecutor saw the note, the defense attorney asked, can we put a little note on the top saying they have to listen to the 911 tape and not just look at the transcript? And we don't know what happened. The only thing we do know is that the defense attorney was participating in formulating the response and that the defendant had no objection whatsoever to what happened. So there's no, and I just want to skip ahead for 1 second. I think that the issue shouldn't be reached on appeal. Because of that reason and because of the lack of preservation. But I also just don't want to sit down without saying at the end of the day, there's nothing here that was inappropriate for the court officer to do. I mean, the cases are so clear that for a court officer, even if, assuming everything that my adversary assumes happened, and the court officer walked into the jury room and said, you asked for the transcript, but you can't just read the transcript, you have to listen to the 911 tape, that's the evidence, that wouldn't have been improper, even if that's what happened. I mean, there are cases, I cited 4 cases in my brief where almost that exact same thing happened, and there was nothing improper that's considered ministerial.
So, counsel, before your time is up and you have 1 minute, could you please, did you wish to address the excessive sentence argument?
Just to say that, to second guess the trial judge's determination here, I mean, the sentence that was given this person's record was on the low end of what was possible. I mean, this defendant was eligible to be discretionary persistent. My office, we didn't seek that in this case, given the facts of the case and the circumstances. But what we did ask for was more than what the judge imposed. You know, that my adversary cited a case, a similar case, although there wasn't a robbery. I think it was just a theft with a forged instrument case where the sentence was reduced. But in that case, what the sentence was reduced to was the sentence that was actually imposed by the trial court here in a more serious robbery case with a threat of force. So I would just.
Do my colleagues have any further questions?
No.
No. Thank you.
Thank you very much.
Mr. Becker, you have 1 minute.
Thank you. So in the record, the court says, I'm informed by the court officers that during lunch, they saw the videotape. They listened to the 911 call with the instruction that they have to listen to it, not just hear the transcript. And again, at the very minimum, it's unclear whether the court is referring to its prior instruction, and more likely that the court is referring to the court officer. Now, on the merits,
but that statement alone, those are not inconsistent with what the court has said earlier. So it's just merely then, in a sense, the court officer is repeating. It's like a tape recording essentially, without adding any sort of embellishments or adding any adjectives to the statement. So I don't understand how that requires a reconstruction hearing.
I have 2 points on that, Your Honor. So first, the prosecution does argue that the court's instruction was ministerial and simply a reminder of what the judge had instructed the jury during trial. But there's no case law to support that a court officer has the authority to remind jurors of a court's legal instructions. And in fact, in Ahmed,
well, counsel, was there an objection to when the court made that statement very early on in the trial, where he told the jury that you're to look at you're to hear the 911 tapes and don't rely on the transcript? Was there an objection lodged to that statement to the jury by the defense?
No, no, Your Honor. There was no objection lodged to that, and it was not an incorrect instruction. The point is that it was the judge's instruction to give. The judge alone could give that instruction at trial. The prosecution does not contest otherwise, and there's no reason why the court officer can then give this instruction during deliberations, the most sensitive portion of the case. And I think it's worth further emphasizing that this actually was not fully consistent with the judge's initial instruction. The initial instruction on page 55 was that if there is a conflict between the two exhibits, the tape governs. This is different than an affirmative instruction to listen to the 911 tape, and there was absolutely no reason for that instruction to be given after the jury had simply requested all the exhibits and then, yes, only referenced explicitly the transcript.
Counsel, your time is up. Thank you very much.
Thank you.
Next case is Cohn versus Nation Star Mortgage.
Yes, good afternoon, Your Honor. Adam Swanson for the appellant Nation Star. And may it please the court. The issue in this case is just who is the respondent? Is the respondent David Cohn or David Cohan? Mr. Cohn, misrepresented in the caption of this case, in the verified complaint and affirmation motion practice.
I see, excuse me, this is Judge Mazzarelli. I see the main issue a little differently. I see the main issue as to whether or not when and whether or not the statute of limitations has run. That's what I see as the issue here.
Okay, so the question, this was a quiet title action to discharge the mortgage under the statute of limitations, and it is Nation Star's position statute of limitations has not run for 2 reasons. The first reason is the loan is not accelerated until judgment enters. And the second reason that Nation Star argues the statute of limitations has not run is because nobody has inquired into whether there was a tolling of the statute of limitations while Mr. Cohn or Cohan, whoever he is, was living in New York and under a false name, and Nation Star was unable to locate him. And the record is replete with instances where we had tried to make service and found 2 people named Cohn and were unable to serve them. And therefore, it was difficult to ascertain just who Mr. Cohn was.
Doesn't the statute of limitations start to run when the debt is accelerated?
That's correct. Under CPL 206, the point of acceleration is when the statute of limitations starts to run on the entire mortgage debt, Your Honor. So because it's an installment contract, as each payment gets missed, the statute runs on each missed payment until the point of an acceleration of the mortgage, then it starts to run on the entire mortgage.
Well, when the first foreclosure action occurred, you didn't sue for just one installment. You sued for the entire amount, didn't you?
Well, so the complaint is filed with an election to accelerate the mortgage. It's like an option in a contract. You exercise the option. But because under the mortgage at issue, the borrower retained the right to reinstate the loan, it hadn't actually accelerated at the moment the election was made.
So your view is that every month from now until the mortgage is completed, that's the or until it could keep going for 30 years. Because there's a new, say you have a 30-year mortgage, there's a new payment due every month.
That's correct. And if the loan was never accelerated, then there'd be 30 different statutes of limitations and 30
But it was accelerated here.
Well, no, we pleaded an election to accelerate. That doesn't mean that acceleration, as defined by New York law, came at the moment of acceleration. The election.
I'm confused. I'm very confused.
Sure.
I'm to the point of befuddlement.
Okay, so take it back to Albertina versus Rossborough, which is the seminal Court of Appeals case on the issue of acceleration. What the Court of Appeals said in that case was that when acceleration occurs, it's controlled by the terms of the mortgage, the contract. It's just an ordinary contractual interpretation. And in the Albertina case, the mortgage that was used was the standard statutory form mortgage. And under that mortgage, the lender had an unqualified right to accelerate, which means that when it elected to accelerate, acceleration happened. They happened simultaneously. But in the mortgage at issue here, the borrower retains a reinstatement right that allows the borrower to continue with installment payments. So the point in time when the borrower has to pay the entire mortgage doesn't actually arrive until the point of acceleration per Albertina, controlled by the mortgage, which here is when the judgment enters, because that's when Section 22 of the mortgage takes the borrower's right to make installment payments away. And that's why
counsel, when would that, so under your theory then, would this statute begin to run?
The statute would begin to run when a judgment entered, and here the judgment of foreclosure and sale did not enter. In fact, it was vacated by Mr. Cohn when he revealed that he is actually Mr. Cohan and testified in a related proceeding as to that fact. So a judgment is never entered. A mortgage is a 30-year obligation between the borrower and the lender, and the parties reasonably anticipate this ongoing relationship. So the idea that you could have 30 different breaches is very well settled. It's within the parties' expectations. So it's the entry of judgment is the point at which the borrower's got to pay everything. So
counsel, who's the borrower? Let's try. Who's the borrower? Who's the borrower in this case? Not Cohen is not the borrower, right?
That's correct. The borrower is a gentleman named Alberto Morales, and
right.
Just knowing you were on the panel that decided an appeal in our foreclosure action.
Right.
And what happened there was we had obtained a default, and then Mr. Cohn came and he said, no, I need to vacate this. You never served me because you always called me Cohn and I'm Cohan, right? And now 6 days after he testified that in the Supreme Court, he commenced this action as David Cohn, not Cohan, to quiet title in his name. And that's the genesis of the misrepresentation he made here. So our position, to get back to the original discussion, is that the loan didn't accelerate. The loan didn't accelerate because judgment had never entered. Foreclosure and sale had never entered against Mr. Morales, and that's as controlled by.
That's not. I don't think the case law says that the acceleration is dependent on a judgment being entered. I understand case law to say that once you commence an action, that in and of itself accelerates the loan, right? And the only way you're going to stop the clock from ticking is to have a clear, unequivocal, saying no. The bank or the lender is going to have to say unequivocally to the borrower, okay, fine. You know what? We're not going, the loan is no longer accelerated. Here's a new payment plan. We're going to go back to the old way, not some of this sort of like ambiguous, amorphous, because the way I understand the case law, it's very clear. You commence an action, You're accelerating the loan. You don't have to wait for judgment to be entered. That's not the rule.
Well, the rule in Albertina versus Rossborough, Your Honor, is that the terms of the mortgage control, and where the lender's option to accelerate under the contract is unqualified, Your Honor is absolutely right. When the election is made, acceleration occurs.
Right.
But here, the contract continues the mortgage as an installment contract until the judgment enters. So, to give you an example, if you commence the act,
Counselor, actually, your time is up, but thank you. We have your briefs. We'll consider it. Thank you.
Your Honor.
The next case up for argument is People v. Regional Urban.
Yes, Your Honor. Ariel Reed for Mr. Herbin. Before I begin, I would like to request 2 minutes for rebuttal.
Certainly.
Thank you, Your Honor. Because Mr. Herbin's waiver of the right to counsel was not knowing and voluntary, his conviction must be vacated. Mr. Herbin's deluded and paranoid beliefs, including that he was an indigenous Moor, that his body was a vessel subject to maritime jurisdiction, and that the court and counsel were committing treason against him, led him to want to proceed pro se. But these delusions and paranoia also prevented him from actually engaging with the court in its attempt to conduct an inquiry into the competency of the waiver of counsel. Repeatedly, Mr. Herbin stated that he didn't understand the charges against him, that he didn't understand the nature of proceedings, that he didn't understand the sentencing range. Indeed, during the first inquiry on October 19th, Mr. Herbin didn't confirm that he understood anything the court said during that particular inquiry, which I will note, for your honors, did not include any discussion of the specific pitfalls of pro se representation.
Ms. Reed, hello. This is Judge Mazzarelli. Hi. This is not the first time your client represented himself. Is that correct?
That's correct, Your Honor.
I think he's probably more experienced at trials than many lawyers who've been lawyers for 20 years. He's represented himself 5 times. Is that right?
That's correct, Your Honor. The most recent time he represented himself, this court actually reversed the conviction on the same grounds we're alleging here, that the waiver of counsel was not adequate, was not knowing and voluntary. So while Mr. Herbin does have a history of representing himself, he also most recently had a history of getting.
Yeah, so that's kind of interesting, counsel, I find. So he moves to represent himself. The court then allows him to represent himself. And then if there's a conviction, he appeals the conviction on the theory that he should not have been allowed to represent himself. Don't you find that to be rather interesting?
It gets his cake and eat it too, it seems like.
Well, Your Honors, I think the discrepancy you're noting is the difference between Mr. Herbin's actual beliefs about his capacity to represent himself and the attorneys who represent him.
Counsel, this is Judge Oing. I looked at that transcript. I think it was before Judge Alvarado, correct?
Yes, Your Honor.
Right, and he was pretty. It was actually before Judge Hong. I'm sorry, Gilbert Hong was the judge that was doing the inquiry. I looked at that transcript. It was pretty intense and it wasn't just one day. It was several days worth of discussing with the defendant his application to go pro se. It wasn't given short shrift. I mean, I don't know what else the trial judge could have done in this case here. I mean, maybe he didn't use the explicit language that you're looking for. Do you understand the pitfalls of going pro se? But he sure has covered all the bases in terms of what was going on. And I think this was a 3-day process too. It wasn't a single moment, unless I'm incorrect.
Well, Your Honor, that first inquiry was two days. It was October 19th and October 20th. And I just want to clarify that our position is not that there was anything in particular wrong with the words that came out of Justice Stoltz's mouth. He was the first person to conduct the inquiry. Right. The issue was what came out of Mr. Herbin's mouth. Every time Justice Stoltz advised him of something or asked him a question, he would say, "I don't understand," or he would just not answer the question at all. When Justice Stoltz went through a litany of ways in which he would be benefited by counsel, rather than he asked Mr. Herbin, did you hear me? Do you understand? And rather than respond, Mr. Herbin turned around. Throughout the proceeding, he was agitated about the fact that he was cuffed from the back. Rather than engage with the court, he turned around and asked the court officers to uncuff him. So despite, Justice Stoltz's best efforts, and what he said,
I'm more interested in what Judge Hong did afterwards, because he was the trial judge. And again, the application went before Judge Hong. And he made reference to he made reference to the deliberations before Justice Stoltz. And Judge Hong was going through the whole litany of question and answers with him too.
Actually, Your Honor,
two different judges, I think.
Actually,
no, counsel, you have 2 minutes in rebuttal. We'll hear from your adversary. Thank you. Okay. People?
Good afternoon, Your Honors. It's Vincent Revelisi for the people. I think here, if Reginald Herbin really hadn't understood, that would be a problem. And he said he didn't understand, but what he didn't understand was that he was obsessed with jurisdiction. This is something that defendants have done for years. The psychologist who analyzed him for 730 said that he was just obsessed with the jurisdiction thing. They had seen this before, the indigenous war argument. I believe that I put a cite to a description of that on the web. But when Herbin was actually discussing this with Justice Hong later, he confessed that he knew all along what was going on and that he just didn't want to talk until he could get this jurisdiction thing resolved. And now that he had been told it was common law, now I understand. This is what he said on April 3rd to Justice Hong. So he wasn't not understanding what words the judge was saying. He was obstinately refusing to converse with the judge because the judge wouldn't say why the judge had jurisdiction.
And when he was questioned as to his understanding the charges, etc., wherein he stated he didn't understand, there was also information elicited as to his age, education, his work experience, as well as his contacts with the criminal justice system. Is that correct?
That is correct. On a couple of occasions, on both dates, on the 1st, the 19th and the 20th of October before Justice Stoltz. And he also told Justice Stoltz at the end of the second day that he did understand everything that the judge had just said. So that was after all of the things that had been said for both days. He said, I understand at the end. So even on that, he's eventually admitted that he understood. But I would submit that even the earlier not understanding was really just an obstinate obsession with the jurisdiction question, not that he didn't understand the words. And in particular, Justice Stoltz emphasized the very things that this court has said were lacking in his other case that was reversed, which is that this is an adversarial system where there's a benefit to having a lawyer and that it's dangerous to represent yourself. This was repeated over and over again to him, not to mention that he's also done it himself several times. So I don't think there's any lacking of understanding here. I think that was really just an obstinate connection with the jurisdiction issue. And Justice Hong really got him to admit that on April 3rd when he said that he was just saying that he didn't understand because they wouldn't discuss jurisdiction. In fact, if you go back to October 19th, when Justice Stoltz was talking to him, the defendant said, you could say it 1,000 times and it won't be clear until you make known the jurisdiction that this courtroom is operating under. So he revealed his hand there as well. I don't think there's any question that Mr. Herbin understood what was going on. He was just being a bit difficult, and the judges realized that, and they eventually let him do what he had a right to do, represent himself.
Thank you. Anything further from any of my colleagues?
Yes, Your Honor. I want to address Justice Owings' question about whether Justice Hong went through the litany, the pro se inquiry again. He actually did not go through the pro se inquiry again. He discussed matters about the indictment. Mr. Herbin believed the indictment was counterfeit, about Brady material, about jurisdiction, which, as my adversary notes, was Mr. Herbin's main concern. But he actually specifically said, I am not going to revisit the pro se determination made by Justice Stoltz. He said that he would have made a different decision than Justice Stoltz about Mr. Herbin's ability to proceed pro se and his competency, but that he wasn't going to revisit that determination. And to the point about, Mr. Herbin being obstinate versus not understanding, when we put that determination in the hands of the court, if somebody says, I don't understand, and we then ask the court to determine, do they really not understand or are they just being obstinate? I think we get into really troubled waters. The court is not a psychiatrist who's fit to determine whether when somebody says, I don't understand.
Counsel, he passed the 7:30. He had a 7:30 hearing, correct?
Yeah.
That's why we have psychiatrists. I'm not a doctor. We had a 7:30 here and he passed the 7:30.
Your Honor, the 730, however, was for the purpose of determining his fitness to stand trial. It was not ascertaining whether he understood the intricacies of what he was waiving in terms of counsel. It was a completely separate inquiry. The 730 did determine that.
My understanding from the 730 is that you're also questioned as to whether you understand the charges against you. They also asked you, my understanding is, who the judge is, who the attorneys are, who the district attorney, who the assistant district attorney is, who the DA is, etc. So those questions are put to the individuals during the 730. So if he stated something, you know, outlandish, quote unquote, outlandish in response to any of those questions, and I don't believe, one, it would have been noted on the 730, which I don't believe that it was, and two, I don't believe that he would have come back fit.
Your Honor, you're correct that he was asked about the charges and the roles of the judges and prosecutor, but the purpose of a pro se inquiry is also mostly to determine whether somebody who's electing to waive counsel understands what that means in terms of, you know, what they are foregoing in terms of their defense. And he wasn't asked those questions at the 730 proceeding. And when he was asked those questions by Judge Stoltz, he said, I don't understand. And so, you know, we can 2 years later assume that he was just being difficult and that he really did understand, but that's entirely speculative, and a defendant's Sixth Amendment right to counsel should not be based on something so speculative as, you know, we don't think he meant what he said.
Thank you, Counselor.
Thank you.
People v. Jose Perez.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Jose Perez. The court should have granted Mr. Perez a new attorney to represent him on his application to withdraw his plea after defense counsel disparaged that application, creating a conflict of interest.
Well, that's the question, counsel. Was there, in fact, an application to withdraw his plea? In reading over the minutes, I don't see a statement by the I don't see an application to withdraw his plea. And I thought that during the sentencing, he was asked and he stated that he wanted to proceed.
The crucial point here, Your Honor, is that before Mr. Perez is given any opportunity to say anything whatsoever on the record, defense counsel launches into this unsolicited attack on his application. He had said to the probation department that he wanted to withdraw his plea because counsel had been ineffective and because he had been misled about the plea. He has no opportunity then, once the sentencing starts, before defense counsel starts attacking that application, to make his own application and expand the record. And then his subsequent statement, it is what it is, I will just take the plea, is made only after defense counsel has disparaged the motion.
Well, were the defense counsel statements actually disparaging remarks? My reading of the transcript was that after looking over the pre-sentence report, the judge stated apparently, you know, the defendant had made certain statements to the probation to the probation department, and that the counsel then said that it was a surprise to him concerning the plea because apparently he thought that the defendant was satisfied with the plea. So counsel said he was surprised because he was under the impression that they had a good relationship.
Counsel said much more than that, respectfully, Your Honor, and I'd urge you to review page 3 of the sentencing minutes. Counsel goes into, he does express surprise repeatedly, but he also says that they've spoken on the phone, they had a video conference, he explained the ramifications of the plea, and crucially, this is the crucial piece, he tells the court that he believed Mr. Perez had pleaded guilty knowingly and intelligently. That was a legal assertion about the legal merits of Mr. Perez's application to withdraw the plea. And it was tantamount under the circumstances of saying to the court, this application has no legal merit. That is precisely taking a position adverse to the application.
Well, counsel, where in the record does the defendant specifically state that he wishes to withdraw his plea?
Mr. Perez had told the probation department, as the court acknowledged, that he
not to the Department of Probation. Where to the court? The Department of Probation cannot withdraw a plea or cannot vacate a plea, is my understanding. So where to the court did the defendant specifically state that he wished to withdraw his plea?
he never had that opportunity, Your Honor, before counsel made these disparaging remarks.
And did he have the opportunity after remarks made by counsel?
Well, Your Honor, that's really not relevant because he was entitled to the opportunity to make his application with the aid of unconflicted counsel. He was denied that opportunity because by the time he was permitted to say anything, the conflict of interest had already arisen. Defense counsel had already disparaged the plea. We can't expect defendants to, in effect, pursue these motions pro se after their lawyers have already disparaged them. And if you look at
continue to use the term disparage, so you're using that term because counsel stated that I thought we had a good relationship, and because in my opinion the plea was knowing and voluntary, that is disparaging. Those are disparaging remarks on the part of counsel.
Yes, Your Honor, that is equivalent under the circumstances to saying this application has no legal basis. Counsel doesn't need to be mean to the defendant in order to disparage his motion. He just needs to say, in my view, this motion is not legally meritorious.
Counsel, I gotta tell you, I'm looking at the transcript right now, the sentencing minutes, and where is it that you say that counsel disparaged him? Because the court, after counsel says to the court, you know, I'm quite surprised about what you just told me, because the court says in the pre-sentence report, he states that he was misled into taking a plea and asking for an 18B attorney. And that's when, and counsel says, this rather surprises me. And the court goes on to say, I will ask if there is something that he feels he was misled about. I don't know what that would be, and I'm not sure what his current position is. Mr. Perez, anything you want to say? No, Your Honor. It is what it is. I would just take the plea. So where is it that counsel disparaged him? I can't see, unless I'm reading the wrong transcript, counsel. Where is it?
What counsel says, Your Honor, and this is quite clear on page 3, is
I'm looking at page 3 right now.
I was under the distinct impression he was taking the plea.
No. I was under, no, don't add the word distinct, counsel. It says, I was under the impression that Mr. Perez and I had a very copacetic lawyer-client relationship from the beginning. We're spoken in court, smoking on the telephone.
And that he was taking the plea knowingly and voluntarily. That was the question.
And I explained all the ramifications of the plea, and I explained why he's being considered a mandatory persistent felon based on his prior record. And again, I am surprised by this, but perhaps the defendant would like to speak. So how is he disparaging the defendant by saying that?
Because if he comes into court, Your Honor, and says, my client wants to withdraw his plea, I believe there's no legal basis, but let him speak. What he's done is created a conflict at that point. He said,
counsel, you're telling me the way you just make, according to your statement there, you're saying defense counsel knew ahead of time, before coming into court, that the defendant did not believe that his services were adequate. And based on this transcript, I think the defense counsel was totally sandbagged when the judge told them about it.
Well, defense counsel had the pre-sentence report, Your Honor. Clearly, they're coming in and saying this in light of the quite specific statement Mr. Perez made to the
probation
department.
Thank you, counsel. You have time on rebuttal, I believe. Yes, you do. Yes, people.
Good afternoon, Your Honors. Michael Yetter for the people. To pick up on some of Justice Weber's questioning, first of all, there was no plea withdrawal motion here. You know, the fact that the defendant expressed unhappiness in the pre-sentence interview with the probation department about, you know, wanting to withdraw his plea and that, you know, he was somehow misled by counsel is not the proper forum to make a plea withdrawal motion. This defendant was certainly well aware of that, being the veteran of 6 criminal convictions, most of which I believe were by plea. And I don't believe there's any case pointed to in any of the briefing where a plea withdrawal motion has been successfully made in a pre-sentence interview. And certainly in the facts of this case, nobody actually treated defendant's statements as a plea withdrawal motion. The court certainly didn't think it was a plea withdrawal motion.
Well, your adversary argues that he never actually had the opportunity to do so, because from the beginning, his attorney made certain disparaging remarks and therefore forestalled him from making a motion to withdraw his plea.
And respectfully to my adversary, Your Honor, he's wrong on both points. One, counsel did not disparage his client's asserted basis for his motion. All he did was explain his representation in this case.
Oh, but counsel, at the end, in the transcript, he did say, well, let's hear from Mr. Perez, what he has to say, because defense counsel was, I think he said it twice. I'm surprised. So let's hear from the defendant. And the defendant said, it is what it is. And that was his opportunity to lodge in, or at least explain to the court what his position was. And perhaps from that explanation, we can extrapolate a motion to withdraw his counsel, right? But he didn't do anything. At least
That's right,
unless I'm reading the wrong transcript.
I think you're reading the right transcript, Your Honor. Counsel, again, after explaining, his understanding of the situation, says maybe the defendant would like to speak. The judge agrees, and he asks the defendant, "Is there anything you'd like to say?" And the defendant says, "No, I'll take the plea." So this is a situation where the defendant was afforded the opportunity to make a plea withdrawal motion. And this is a defendant, again, who has pled guilty before. He has experience in the criminal justice system. He's not being shut down by his attorney at all.
But can the argument not be made that the attorney, by stating that he believed that the plea was knowing and voluntary, that he was taking a position adverse to his client and perhaps adverse to the interests of his client?
Well, no. Again, Your Honor, you can't. But I just want to clarify, I guess, the factual point.
Why can't you? Why can't Judge Weber's question be the facts? That is an opposite position.
Well, because the attorney never said he believed that the plea was knowing and voluntary. What he's saying is, I was under the distinct impression that he was taking the plea knowing and voluntary, which I believe he's referring to what he understood at the time of the plea. Now, after the defendant has made these assertions,
you're parsing those words rather tightly there.
Well, I think I'm just reading them in a straightforward manner, Your Honor. I don't see at all where he says, I believe the plea was knowing and voluntary. He's talking about his impression at the time, and then he says that maybe the defendant would like to speak about what he said in the pre-sentence interview. So I don't think that can be fairly read as disparaging his client's position, which he had not yet even articulated, and then declined to articulate when he was given the opportunity to do so. And I just want to make one other point. I
think that's what you're saying, counsel. I'm sorry, this is Judge Orion. So what I'm hearing is that the fact that defense counsel provided an opportunity for defendant to speak his mind, that cuts away from any impression or any sort of opposed. In other words, taking that cuts away from a defense counsel being opposed to defendant's position, right? I mean, by just giving him that, and I mean, he didn't say, and that's it, Judge. So your argument is, as I understand, is that that opportunity there was where it kind of takes away from any sort of position that defense counsel may have had at the time or even at the moment.
Right. I think that's right. I mean, the counsel is giving defendant the opportunity to make his claim. I'm not sure counsel knew what the claim was, right? Because the pre-sentence interview statement was, my lawyer was ineffective and I was somehow misled. And I don't know whether defense counsel knew what the precise basis of this motion was, which is why it's difficult to conceive that he took a position against a motion that was never made and the basis that has never been fleshed out. In fact, even now on appeal, it's not clear what the basis of the plea withdrawal motion actually is. So I think counsel was saying, here's what I did, and maybe defendant would like to explain more about what his position is. But again, to this day, defendant has not articulated a basis for the motion.
Thank you, counsel. Your time is up. Yes, counsel, you have 1 minute in rebuttal.
The key point is that Mr. Perez needed to be afforded the opportunity to make his application with the aid of unconflicted counsel. Once counsel said that he didn't think Mr. Perez had pleaded, or rather that he thought Mr. Perez had pleaded guilty knowingly and intelligently, he created a conflict of interest. I'd refer your honors to Desler and Faulkner and Colson, the cases that we cited in our reply brief, which make clear that that kind of statement is taking a position adverse to your client. And so once that happened, he had no opportunity with the aid of unconflicted counsel to make his application for plea withdrawal. The statute says, 220.60 sub 3 says that a defendant can make that application at any time before sentencing. So And counsel really butts in and makes this statement before Mr. Perez has any opportunity to lay out the basis of his application for plea withdrawal. He shuts it down by taking this position adverse to Mr. Perez. What the court should have done.
Counsel. Thank you very much.
Thank you.
Next case up for argument, Radio Drama VK.
Good afternoon, Your Honors. May it please the court, Gary Friedman, Greenfield Stein and Senior, for the appellant Richard K. May I reserve 1 minute for rebuttal, please?
Yes, counsel.
Thank you. Here, Hyman Brown was allegedly defrauded on July 8, 2003 and October 20th, 2004. This proceeding by Radio Drama Network, a disinherited beneficiary, was commenced more than 11 years later, on December 14th, 2015. It was also 5 years after two of its officers and directors were given a copy of the 2002 trust agreement favoring Radio Drama Network, and it could then have reasonably discovered this claimed fraud. In denying
Counsel, excuse me, this is Justice Shulman.
Yes.
But doesn't the statute begin to run at the time of Mr. Brown's death as the grantor? Because that's when whatever rights triggered come alive, no pun intended.
We respectfully submit that that's not what the law is, and that the surrogate's decision and the one or two other trial court decisions that so hold turn the statute of limitations jurisprudence on its head. Hundreds of cases going back hundreds of years have held that a fraud claim, the cause of action arises when the fraud occurs. And the fraud here allegedly occurred back in 2003 and 2004. The fact that the disappointed beneficiary here could not have commenced an action before Hyman Brown's death doesn't change the fact when the cause of action accrued.
Counsel,
and that's exactly...
Counsel, this is Judge Oring. I'm sorry to interrupt.
Yes.
Yeah, I thought about that. And the interest, unless I'm wrong, completely wrong, a fraud occurs in 2002, let's just say, right? While the grantor is still alive. The grantor, unbeknownst to anybody else, could in essence get rid of the fraud by doing something without realizing it. In other words, if the fraud if there were actually a fraud that was committed in 2002, between that point and when the grantor dies, that fraud could be in a sense repelled by the grantor if the grantor did something without any sort of motivation on anybody's part, so that there's no fraud at all. Do you follow what I'm saying? So that you have to, in a sense, then wait for the grantor to die before it really accrues, because between the time of the actual fraud and when the grantor dies, he or she could ameliorate or counter the fraud or fix the problem, whatever it is, right?
I'm not sure I'm following you, but our entire tort jurisprudence...
It has to do with the accrual of the fraud action.
Right.
Fraud claim.
And our entire tort jurisprudence is that the claim accrues when the wrong occurs. And the wrong occurs when the misrepresentation was allegedly made.
Okay.
And so, a perfect example.
This is Judge Mazzarelli. Am I correct that the terms of this trust wouldn't come into effect until the passing away of the grantor?
No, it was a funded.
I can't hear you.
Oh, you're muted, counsel.
Oh.
I didn't hear your response. I'm sorry.
Did my camera go out?
Okay, you're back.
Yeah.
You're back.
Okay, I don't know what happened. I must have pressed the. Anyway, no, the trust was funded, and Hy Brown was the income beneficiary during his lifetime. The only thing that happened at his death is the people who he designated as his beneficiaries then took. But during his lifetime, he was, signing checks, Hyman Brown Revocable Trust. It was an operating trust.
But he could have changed that at any time, correct? Because it was revocable.
Right, but he was wronged, if he was wronged at all, back in 2003 and back in 2004. And if he was upset about it, he could have sued the lawyer who drafted the trust agreement and collected, damages for the legal fees incurred in preparing all the trust documents. So that's when the wrong occurred. And if there's to be any change in when,
Counsel, that's a good point. The wrong occurred in let's just, for argument's sake, the wrong occurred in 2002. It didn't really become, it's still, to me, inchoate between 2002 and the grantor's death. So when the grantor dies, your fraud claim now becomes real. The fraud claim is now rock solid, because that, to me, is the difference. And that goes with any fraud claim. You can have accrual of the fraud claim at one point in time, but it's still sort of inchoate in a lot of ways, because, the defendant is going to argue a lot of defenses. And in this case here, the fraud claim doesn't become real until the grantor dies, because at that point, there is no opportunity for the grantor, who controls everything, to ameliorate the fraud or to at least counter the fraud. I mean, do you see that argument?
I see what you're saying, but
Okay,
the Second Department, in essence, implicitly rejected that argument in the von Blomberg case that we cite in our brief on page 17. There you had a claim that a decedent was defrauded in 1996 to take title to property as joint tenants with right of survivorship, and the claim was made it should have been by a tenancy in common. And then, so that the property would then pass by to her estate. The decedent died 8 years later. A residuary beneficiary of that decedent's estate sued the co-owner for fraud, the surviving joint tenant, saying, "Hey, you defrauded, my decedent, and now I have nothing." But up until the moment that decedent died, because it was a joint tenancy with right of survivorship, that decedent could have unilaterally severed the joint tenancy and, to use your phrase, and undone the so-called fraud. But the Second Department held no, the fraud occurred when the misrepresentation was allegedly made back in 1996. Here, because that's the essence of a fraud claim, is a knowingly false misrepresentation made with intent to deceive. If that happened, it happened here in 2004 and 2003, not in 2010 when High Brown died. And, and it's not unfair. In 2010, the offices of Radio Drama Network knew or reasonably could have discovered this alleged fraud, yet they waited 5 years. The legislature has determined that in fraud cases, if a person has been so successfully defrauded that they don't discover it, that 8 years goes by and they couldn't have discovered it with reasonable diligence, they still have 2 years. Well, here, Radio Drama Network waited 5 years.
Counsel, you have 1 minute in rebuttal. Well, we turn to you. Yes, Mr. Sesser?
Yes, good afternoon, Your Honors. Gary Sesser, Carter Ledger Milburn for Petitioner Respondent Radio Drama Network. It has been settled law in the Surrogates Court for the past 25 years that revocable trusts function as will substitutes and should be treated the same as wills for all purposes, including the statute of limitations. And just as there is no claim to set aside a will prior to the death of the testator, there is no claim to set aside or reform a revocable trust until the grantor dies.
Is there, this is Judge Mazzarelli. Is there an appellate division or court of appeals case that recites that rule?
No, there is not. And I
So we're
assume that's why we're here.
So we're depending on the cases from the surrogates courts. Is that correct?
We are, and we're also depending on common sense.
That's a rarity in the law, but that's okay.
If I change my will tomorrow and disinherit one of my children, can that child run into court the next day while I'm still alive and try to reform the will? No, it's not right. I could change my will a half a dozen times between now and the time that I finally pass away. So the reason is the same with the revocable trust. They can be amended or revoked at any time prior to the death of the decedent.
So so essentially, Counselor, in a estate situation, in these kind of cases, the estate, when you're dealing with wills and probate and all that, it's the fraud claim is not complete yet. You're still missing the component of the death of the grantor or the death of the devisee, right? I mean, that's it. Once the death happens, then you got a real claim, because between the time, because anything in between, as you just said, you can correct the problem, or you can say to you could say to your child, forget it, you're not getting a dime now.
No, I mean, to play it out, let's assume for a moment that the fraud was discovered before Hyman Brown died, and radio drama would have gone to Hyman Brown, and there are two possibilities. One, he would have said, you know, I've been defrauded, fired Mr. K, changed it back to the way he wanted it. We don't have a claim, it's fixed. The other is he would have said, no, that's what I wanted, in which case we don't have a claim either. So it doesn't make sense. They haven't explained what claim we would have exactly prior to Hyman Brown's death. So the the statute says accrual of the cause of action, and the Court of Appeals has said that the statute of limitations can't start to run until you actually have a claim. Those are the Labello and the Cronus cases cited in our brief. So I think where they really kind of gave it away is on page 7 of their reply brief, where they said, look, the accrual takes place when the fraudulent acts took place, at least here, where there was no change to the relevant provisions of the revocable trust prior to Hyman Brown's death. Well, the fact of the matter is, until Hyman Brown dies, you're not going to know that there were no changes to the revocable trust. So they're basically proposing a rule where the statute of limitations would expire before radio drama had a cause of action that it could actually pursue. So that is the point. They've also made an argument.
Counsel, so the counsel, I'm sorry to interrupt. So essentially, I mean, your clients didn't know what was I mean, they're not on notice in that regard about the changes in the trust. I mean, why would they know, right?
They didn't know.
They didn't know.
There's nothing in the record. I mean, this comes up on a motion to dismiss. All the allegations of the petition are taken as true.
Correct.
But beyond that, they allege that directors of radio drama found out afterwards. Sometime after Brown died.
Thank you.
The statute says 6 years, or 2 years from discovery, whichever is greater, not whichever is less. So we had 6 years, and it was timely brought. The only other point they've raised is whether we've stated valid causes of action based on the 175-year-old precedent, Hutchins versus Hutchins, that says you can't have a claim for tortious interference with prospective inheritance. That's not a claim we've pleaded. We've
Sir, this is Judge Shulman. Essentially, you're seeking equitable relief, and Hutchins would allow that under these circumstances, correct?
Yes. The case where the Court of Appeals made that perfectly clear is Latham versus Father Devine. It's a 1949 Court of Appeals case, and made it clear how limited the Hutchins precedent actually is. No application at all to equitable relief. Hutchins was decided at a time when you had to go into different courtrooms to get relief at law and equitable relief. So Hutchins is limited. It certainly has no application to challenges to testamentary instruments. Court of Appeals case in Putnam involving an attorney drafter as here, goes back to 1931. You disinherited. You have to be a disinherited beneficiary in order to have standing to challenge a will or a revocable trust. So Hutchins really has no application here at all. the surrogate correctly analyzed the causes of action that we did plead in the petition and found that they, were sufficient. As you know, the standard on a motion to dismiss is whether we've pleaded facts that fit within any cognizable legal theory, not whether they can think of a cause of action that we didn't plead that the New York courts don't recognize. I mean, that's basically the argument that they're making.
Thank you, Mr. Sesser. Appreciate it. Mr. Friedman, you have 1 minute in rebuttal.
Thank you, Your Honor. The fact is, Radio Drama has asserted money damage claims against Mr. K. They are nothing more than claims by a disgruntled heir for tortious interference with prospective inheritance. And the Court of Appeals, as recently as 1996 in Vogt v. Whitmire, this court in a number of cases, Jacobs v. K, Judge Mazzarelli was on the bench, Bull versus Kimball in 2003, all hold that's not a recognized tort in New York. Let's not forget that Radio Drama Network waited 5 years to bring this case. So, even if it couldn't have brought the case until Mr. K died, they certainly could have reasonably discovered the fraud in August of 2010. They waited until December of 2015. And last, to say this is a will substitute is really an imperfect analogy because you don't have 6 years to challenge a will. This interferes with the settled public policy in New York for the prompt administration of an estate. In a probate case, you've got to file your objections to probate on the return of citation or request 1404 examinations, and then you have 10 days, only 10 days from when those examinations are completed to file your objections, all because the legislature recognizes that estates need to be wound up quickly. Here, a trustee would act at his or her peril in distributing assets. He'd have to wait for 6 years and a day until the creator of the trust died, because they'd be afraid that somebody may come out of the woodwork and say, oh, Mr. So-and-so was defrauded and therefore this trust is invalid. Any change, I respectfully submit that any change to the settled accrual rule for a fraud claim should come from the legislature and not from the surrogate.
Thank you, Mr. Friedman. We appreciate it. We have your brief. Thank you. The next case is HTRF Ventures versus Paramastelia North.
Good afternoon, Your Honors. Michael Rogers from Wasserman, Grubin, and Rogers on behalf of Paramastelia North America. And if I may, Your Honor, have permission for a 2-minute rebuttal?
Yes.
Thank you, Your Honor. The lower court had correctly dismissed 4 of the 6 causes of action in the complaint of HTRF, but let 2 remain. The 2 they let remain were for breach of contract and for breach of express warranties as against Paramastelia. It is clear that—
So, counsel, I have a question. Counsel, this is Judge Owen. I've got a question. So, correct me if I'm wrong. Supreme Court, and I think this is where it's all emanating from, Supreme Court found that there was no ambiguity about the 10-year warranty that was provided by the manufacturer, and Supreme Court said that that 10-year warranty can be applied to your client. Correct?
Yes.
That's how you get. That's one of your arguments, saying no, the 10-year warranty doesn't apply to my client, because from that flows the statute of limitations argument. Because if the 10-year warranty that the manufacturer provided is applied to your client, then we don't have a statute of limitations problem, because they commenced the action, 7 days under the wire, essentially, in terms of, by my calculation. Correct?
Yes, if the 10-year warranty applies.
So that's your main. That's probably one of your primary arguments. Supreme Court made a mistake when it said it's found the contract or the documents to be unambiguous, and the 10-year manufacturer warranty is applicable or can be applied to the defendant, your client in this case, right?
Yes.
So why is it that that 10-year warranty doesn't, and then one step further, Supreme Court ultimately found there was a factual issue whether or not the defect came within the warranty, which is why it denies plaintiff's motion for summary judgment on these claims.
Plaintiff didn't cross move for summary judgment here, Your Honor.
I thought it was a motion. I thought it was two separate motions, but it doesn't matter.
No, it's not, Your Honor.
So tell me why the 10-year doesn't apply to you when it kind of like not clear, because on the, you tell me why. You tell me why.
Well, Your Honor, there's, and to even put it in greater context, there's also a 20-year warranty.
Well, that's not even, but that doesn't, the Dow Chemical, unless I'm misreading it, is not at issue here, right? The 20-year doesn't.
It's not an issue, but for the point of showing that what all permits lease was required to do, and it's clear from the language of the curtain wall specifications. And the curtain wall specification at Article 1.11 is the only document that's
the 5-year one. That's the 5-year one.
It sets forth all three, Your Honor.
Right. Okay.
It references all three: the 5, the 10, and the 20.
Right.
But what it provides, and the language is that permits to leaser must submit a warranty for 5 years, which is based upon the work, which permits to leaser did, the installation work, everything that it did on the project site. Then it must not submit. It said must provide. You submit and you provide. There's a distinction. You submit the warranty that we were given. Provide one from the manufacturer for the isolated glass units.
Correct.
Right? That runs directly from the manufacturer to the project. Not.
Correct.
It's
correct.
Not,
no, I'm not disputing it. You're right.
Okay.
That's
and
exactly what the
with the and the same thing with and the reason why I brought up the 20 is even the specification stated that we want the 20-year, and when they referred to manufacturer, they said we want like the 20-year Dow Corning VIP.
Right. Correct.
The structural silicone weatherproof.
I just say I don't mean to be shouting at you, but
I love the exchange, Your Honor.
So I'm taking that. I'm taking section 1.11 of the warranty. How do you reconcile that with Article 21 of the designer build agreement, where it says in there, I give you, I being your client, says I will give you the 1 year from the date of acceptance of the project, all right, as a whole by the architect project, and then it goes on to say for such longer period as may be provided in the plan specifications, including all performance criteria, general conditions, special. How do you reconcile that? On the one hand, it's clear the warranty says submit 5 years. I'm only your client. I'm only responsible for 5 years. The 10 years is the manufacturer. But how do you reconcile with this paragraph here that says, for such longer period as may be provided for?
Your Honor,
how do we do that?
I'm sorry, I didn't want to step on you.
Yeah, how do we reconcile?
Your Honor, I believe you should direct your attention likewise just to the paragraph immediately below.
Yes.
Where the third line from the bottom of that paragraph, still in the guarantees section, Your Honor.
Yes.
Where it states, beginning at the right side, all warranties contained in this agreement shall be specified in the contract documents.
Yes.
And the only contract document, Your Honor, the only sole single contract document that identifies the warranties is the curtain wall manufacturer. I mean, is the curtain wall specifications that provides.
You're right. That it comes. But if you go back to the first sentence of the paragraph that I have an issue with, it says a subcontractor shall expeditiously remove, replace, and or repair at its own expense. So I understand on the second paragraph you're talking about warranties, but on the top paragraph you're talking about the subcontractor being your client having the obligation within the year or such longer period as may be set forth in other documents. So if you got a 10-year
period. And again, that's why I emphasized that the only document speaking as to the periods is the curtain wall specifications. Your Honor, and my adversary cannot argue a point to. There is no other provision. Either it's the 1 year or the periods that extend beyond that based upon the curtain wall specifications. There is not a single other contract document that references that longer period. And most certainly it doesn't go on ad infinitum. That argument that counsel previously tried to make is it just doesn't hold water. You can't have a warranty just to go on forever.
It's not. But that's where I thought there was a problem there. But it's not. The outside limit is 10 years. It's not going on infinite, ad infinitum, forever.
No. It's that's not limited for 10 years. The 10 years is specifically, if you read, is specifically with respect to the warranty for the manufacturer.
I understand
There's
that.
a distinction.
I understand that. What I'm saying is that phrase there, when it says for such longer period as may be provided, I'm saying that that's not saying that it's going to go on forever. That's infinity. I'm saying that ties into the manufacturer's tenure. So at the most you're going to go is 10 years out. You're not going to go past 10 years. That's why I can't reconcile that.
Your Honor's reading of these provisions, then, if I were to adopt it, would also say that it could go on to 20 years, because 20 years is referenced in Article 1.11. And that's not the reason. A manufacturing warranty that's provided here, you don't have a subcontractor become a guarantor to a manufacturer's warranty.
So you know what? Then interestingly enough, our disagreement, our discussion going back and forth, doesn't that create a factual issue now?
No, it does not. Because if the documents and the project records here that we've demonstrated, it clearly provides that the time frame and who is providing the warranties. The warranties were also provided. Let me submit to Your Honor. One of the reasons
Counsel, you can submit on rebuttal, but thank you so much.
All right, thank you. I enjoyed it, Your Honor.
Thank you.
Thank you.
Thank you.
Yeah, Mr. Kowski? Yes, counsel? Who wants to go next?
Yes, Your Honor. This is Ilya Feltrov for respondent. Good afternoon, may it please the court. I'd like to introduce my colleague, Brent Gurney, who has been admitted per hoc vice and requests that he be permitted to participate in the appeal.
Fine, proceed.
Yes, thank you. Good afternoon, Your Honors. Our argument here is that the key document is the design build agreement that Justice Oying was asking about. And the key paragraph is the one that you were asking about.
It's those two paragraphs. Those are really, that's why I made the final point when I was having the debate with counsel, that it sounds like a factual issue if we're having these kind of debates here about what the two paragraphs mean. I know Justice Cohn down below, Supreme Court found that there was no ambiguity, that the 10-year applied. But but they're arguing, no, the 10-year warranty doesn't apply. And that's where I want to just get into this. And I don't know. I mean, he may have a point. Why would the 10-year apply?
Yeah, so the reason that the 10-year applies is because that second paragraph in Article 21 of the design build agreement creates its own warranty by itself. And the only thing that is incorporated from the specifications is the time period, because of the language that you cited for such longer period as may be provided in the plan specifications, etc.
Which I had when we had the discussion, it's either 10 or 20. The longer periods are 10 or 20, because that's the only, we have three periods. We have a 5-year, a 10-year, and a 20-year. So the longer period is not as if it's going to be going out infinity to the end of time. It's at most going out 20 years.
Yes,
but we're not even worried about that, because under the 10-year, you just came in 7 days under the wire under the 10-year, right? So don't even have to look at the 20-year.
Yes, and let me just make one small point. The 20-year warranty is inapplicable here because it refers to a different kind of seal.
Yeah, it's a seal on the outside of the window, as opposed to a seal inside the window.
There's the structural.
I've had my problems too with seals.
Yes, correct. But the 10-year period in the specification sets the outer limit, and that is what is referred to in the second paragraph. Judge Cohen below got this right. There's no ambiguity here with respect to the second paragraph. It clearly says the subcontractor, this is a replacement or repair warranty in the second paragraph. It clearly says the subcontractor has to repair, replace, etc., and they have to do it up to whatever the longer period is that is provided in the specifications. That's just not ambiguous. And it creates a direct warranty in the design build agreement and is directly enforceable by permissive lease.
Well, maybe not a direct warranty, but a direct obligation on the defendant's part to fix something or to repair something.
That would be
maybe using the term warranty is a bit, maybe that may be a misnomer or sort of like confusing, but it is your argument that, look, that's an obligation he's got. He's got to remove, replace, and or repair at his own expense within 1 year or such longer period as any of the other documents provide for. And we got 10 years.
Correct. That's absolutely right. There was a question in your exchange with Mr. Rogers about the contract documents. I want to point out that contract documents includes the design build agreement itself, as well as the specifications and everything else that was specified in Article 1. And as the court below said, we need to read all of these provisions as supplemental and complement.
Well, how would you? Well, what if there were an issue of fact? If there were an issue of fact as to whether or not that first paragraph actually includes the tenure. I mean, that's. Where would that leave you? I mean, in that sense, then you'd have to argue that you got to figure out what they all meant about this first paragraph, right? Did it mean to actually rope in the 10 years or not? Wouldn't that happen then? I mean,
well, if
since I think there's like a confusion going on over here.
No, with all respect. If this court were to determine that the language before us in Article 21 was ambiguous, then it is correct. There would be a fact issue, but that still would not entitle Permis Elisa to summary judgment, and the decision should be affirmed on that basis.
Right.
So they would still lose on that point. But the premise
no, but that taking that point, I mean, it'd be a jury question then as to whether or not, at that point, whether or not 10 years should apply. And neither side getting a slam dunk and a win. And in fact, the only reason why Supreme Court denied the plaintiff's motion for summary judgment, he says, we don't know if this defect comes within the warranty, so I'm going to deny summary judgment. But we got it. But I think defendant saying, well, no, man, it doesn't. The warranty doesn't even apply. So just peeling it back one layer, you'd have to decide whether or not the warranty even applies.
Yes, I agree with everything you've said, but I don't think there's.
Well, that's the first. That's the first that lawyers agree with me. Okay.
I don't think though, Your Honor, there's anything ambiguous about the language in Article 21, and so we never get to all of that. Right. You're correct. They argued a boatload of extrinsic evidence about what people intended and all that, but I don't think we ever get there because this is just not ambiguous on its face, and the court below got that correct.
I'm sorry, Justice Wood, but I hogged up all the questions.
Well, we're used to it, but that's okay. Any of my other colleagues have any questions? Mr. Booth, I think you have 1 minute in rebuttal.
Yes, picking up, Your Honor, is looking at that Article 21 is what's interesting is that 1 year period or such longer period is speaking of to the repairs, replacement, or removal of work that may be found to be defective.
Right.
If you go now to Article in the specifications, Article 1.11, the only of the three time frames that deals with the workmanship issues is the 5-year warranty.
Right.
That's a standalone sentence, and that's the only one that provides for what is to happen if there is a failure with respect to the workmanship, and it mentions it there. A 5-year warranty covering materials and workmanship of the curtain wall system.
Well, you just
it is specific.
Well, you answered your own question. You got so many different time periods, and you got so many different bases of obligations going on. Maybe it's a factual issue here. Maybe Supreme Court.
I submit that it's their engineer's document. Secondly, what I submit.
You guys signed on, and you guys had to read this too, right? I mean, this is sophisticated business opportunities, right?
And we read it correctly. And because even the project record that we added with respect to...
plaintiff is arguing you read it incorrectly, and Supreme Court agreed with plaintiff.
If you see, the 10-year warranty doesn't mention workmanship, it doesn't mention labor, it doesn't mention materials, it mentions...
That's exactly the point. You don't need to, the part where it talks about 5, 10, and 20, you don't have to get to that specific when you have a generality of incorporation in the first paragraph. So it's like incorporating another time period into a paragraph that's more specific. That's where the problem comes in.
More specific is the 5-year, Your Honor.
Oh, it's more specific. Well, you're ignoring the.
Because if I use Your Honor's or even Mr. Brent Gurney's response, the 10-year. How would you cherry pick the 10-year over the 20-year? Why would you cherry pick 10 over 20?
We made that inquiry. I said, well, the 20-year doesn't even come into play because they got it under the wire under the 10-year. We would have the 20-year coming into play if they had not been able to get it on the wire under the 10-year. So the 20-year, fortunately, in this case, we don't have to talk about the 20-year. It's a 10-year.
They were required to get it under the wire for the 5-year. I respectfully submit, Your Honor.
Thank you.
so much. We really
Thank you.
appreciate it.
Thank you, Your Honor.
So much. Really enjoyed it. Thank you.
I enjoyed it.
Thank you, Justice Oing, as well.
Thank you, Justice Weber.
Next case for argument, Kopkov.
Hello, Your Honors. My name is Alex Kovkov, plaintiff appellant for the case. May I ask 1 minute for the rebuttal, please?
Most definitely.
Okay, thank you so much. So, as I pleaded in my complaint and as I thoroughly discussed in my appellant's brief, I'm appealing from dismissal of various causes of actions, and I'm not going to repeat myself because I discussed the elements of the case and why the trial court's decision is incorrect. In this oral argument, I would like to focus on the nature of the case. As you remember, I pleaded 2 different frauds in my case, which is the fraud in the inducement to enter into a retainer agreement and the fraud we just called as a fraudulent scheme or just the fraud. So the difference is that the fraud in the inducement was fully accomplished once I signed the contract. However, as I stated in my complaint and in my appellant's brief, the fraud of the inducement was not the key nature of the case. The idea for my defendants was to defraud me further. And the second fraud became accomplished once they triggered the criminal and civil usury, which was implemented into my retainer agreement. So this is how it works. The defendants promised the price, which is the market price. It's reasonable, and under Rule 115 of New York Rules of Professional Conduct, this is binding. Similarly, under the Rules of Contract of New York is also binding. Then they breach New York Rules of Professional Conduct and their own retainer agreement, prohibiting advancing of the client's cases, and they generate the debt. Even if you look into the invoices, attorneys abandoned my representation almost immediately after I signed the retainer agreement, so I had to defend myself. However, they kept billing me even after I fired them officially, and once they created this cushion of billing, they applied the criminal usury interest, which is, if you look into the page A964 of the record, 3% per every 2 weeks compound, which amounts to hundreds of percent of interest. And this is the nature of the fraud.
So harkening back to the prior arguments, where is the ambiguity in the retainer agreement? You signed the retainer agreement, so does not it speak for itself on its terms? Where is there ambiguity in the retainer agreement?
There's no ambiguity in the retainer agreement. However, it only says the hourly fee billing. It doesn't contain an integration clause in the retainer agreement, and therefore extrinsic evidence which do not contradict this retainer agreement are admissible. So as I represented, I have 6 audio files where I discuss with the attorney the final price for services, which may grow only if I demand additional services. However, I did not, and the attorney did not even perform the job he was meant to do. He breached his retainer agreement, he advanced the case in violation of New York Rules of Prohibitable Conduct, and triggered criminal and civil usury, which is illegal in New York. And that's the idea of the fraud. So as of today, the attorney is seeking, I calculated, $151,000 under this retainer agreement. And this was the key approach of this attorney. This retainer agreement was never meant to be performed, because by performing the agreement, you can't charge the client hundreds of thousands of dollars, which my attorney is doing. In addition, under Rule 4.11 of New York Rules of Evidence, I'm seeking a discovery, and if I find similar occurrences which he did to other clients, I will be able to show the motive to defraud, because under this rule, those prior bad acts are admissible as evidence of a motive. And if we show that attorney has a pattern of defrauding all his clients in a similar way by promising them the retainer fee, hourly fee agreement, which is limited by law by a reasonable market price, and then triggering the criminal usury, which is illegal per se, and charging the clients the money that they didn't agree to pay them, I will be able to show that this fraud is scaled and I'm just one of the victims. And this case is not just about Mr. Kovkov. This case is about whether an ordinary New Yorker should risk to become a financial slave of his own attorney if the attorney decides that any hourly fee agreement has an unlimited price and the attorney may charge whatever he wants in violation of New York rules of professional conduct and his own agreement, which entitles me to a reasonable price, which makes the audio files in agreement binding as it doesn't have an integration clause in that agreement, and because the agreement about the price doesn't contradict the writing itself, so we do not
Thank
apply
you. You
for
have
further
2
rules.
minutes on
Thank you.
rebuttal. Thank you very much. Mr.
Thank you.
McLean?
Good afternoon, Your Honors. It's Kenneth McClellan with Wingate Spadafora, representing the law office of Darrell Sewell and Augustus Subramium. May it please the court, Your Honors. I have a short time, so I wanted to just point out 3 specific issues, if I could. First of all, Your Honors have already addressed, or excuse me, the First Department has already addressed this issue with respect to an earlier order in the case that dismissed the co-defendants out of the case. Your Honors heard Mr. Kovkov's appeal previously on that issue and affirmed Justice Suarez's order on that issue, and the site is 182 AD 3rd 418. It was handed down on April 2nd, 2020, and the First Department held that there was only bare conclusory allegations that the defendants engaged in some kind of conspiracy to defraud the plaintiff, and also pointed out the fact that New York doesn't recognize civil conspiracy as a cause of action. Second of all, I just wanted to point to the record, and Justice Weber, you already raised the issue of where is the ambiguity in the retainer agreement. We don't believe there's any ambiguity at all, and particularly want to point out that Mr. Kovkov is a graduate of a prestigious law school. He holds an LLM. He is not a pro se plaintiff in the strict sense of the word. He's representing himself, but he's highly educated, and for all intents and purposes is an attorney. I'd want to point to page 558 of the record that Your Honors can peruse at your convenience, but
If I may, sir, this is Judge Mazzarelli. How did the amount that he owed go from $17,000 to $28,000 from March 12th to April 2nd? How did that occur?
Yes, Your Honor. I can. I have to refer to the bills. That's pointed out to my client's bills that are in the record at page 557. And you're specifically asking about March, Your Honor?
I'm really asking about what the plaintiff said about the interest rate compounding tri-weekly.
I don't know if the interest is, I don't believe the interest is factored in to that specific time period when they were representing Mr. Kovkov. The work that was done was a motion to dismiss. It was quite involved papers. And Mr. Kovkov was a very communicative client. He sent back a spreadsheet of very detailed comments on the paperwork that counsel went back and forth. Mr. Sewell's office, Mr. Subramium, who was the attorney that one of the attorneys working on the file. That's what generated a lot of the costs in this matter, Your Honor. And but if I could just,
can you just deal with his representation that he's being charged compounded interest?
Well, it does refer to compounded interest in the retainer, Your Honor. But I don't believe I've seen anything in the record where where my client is seeking that a payment of interest in any of the debt collection that they've tried to engage in. It's not referenced in the bills in the record, Your Honor.
So it's your position that the funds sought are for services rendered, not for interest.
That's what the bills say, Your Honor. I understand what's it says in the retainer agreement, but Mr. Kovkov did pay a $7,500 down payment that's referenced in the retainer, and I haven't seen documentation referring to seeking the level of interest that Mr. Cobb has referred to. And if I could just point to the decision that Justice Suarez issued, I believe it was correct. It was an extensive decision. It was issued from a specialized part in Supreme Court Bronx County that addresses legal malpractice, labor law, and other kinds of complex cases. The crux of the decision is that the retainer was not ambiguous, and there was no, and everything relates back to an alleged breach of the retainer. And while Mr. Cobb is referring to discovery with other potential claimants, almost suggesting there could be some kind of mass joinder argument, that's just not the case. I mean, we're only dealing with this one specific claim, and the court found that no legal malpractice cause of action was stated, nor was any cause of action stated or for breach of contract, and everything else flows from that. And the court pointed out that there was no specific promise made in the retainer, and that's an important issue in First Department jurisprudence as well. There was no specific promise for a specific result. Counsel did their job, and they shouldn't be disparaged as they have been. This is a
thank you very much, Mr. McCullough. We appreciate it. Your time is up. Thank you.
I appreciate being heard.
Yes, thank you. Mr. Koploff, you have 2 minutes in rebuttal.
Thank you, Your Honor. First, with respect to interest, this is the copy of one of the invoices, and it says interest. So they charge me interest, and the invoice refers to the contract itself, saying that they charge me upon the conditions of the retainer agreement. And the numbers for services, even when they were fired and abandoned me, were charged only in the beginning, like March of 2018. However, every single bill after was based solely on criminal usury interest. And as of today, every 2 weeks, I have to pay under their agreement $4,500 of interest alone. And it amounted to more than $150,000 total. That's the idea of the fraud. This is why this agreement was never meant to be performed. With respect to ambiguity, there is no ambiguity in the agreement. Agreement is not integrated. It doesn't have the total price. We agreed on the price. I have audio files about this, although my defendants deny that. If you have an hourly fee agreement, you're limited to the market price as a matter of law, and you cannot advance your case because Rule 1.8E of New York Rules of Professional Conduct prohibits that. Because of all these violations, they created the debt to apply criminal usury and ended up with $150,000. So what they're going to do now is they're waiting for this court to decide the issue, to come back to me and keep extorting the money they never earned, as they abandoned my representation almost immediately after I hired them. And I had to go to court. I had to deal with the attorney of the opposing party. I had to write the responses to the attorney. So technically, I had to represent myself in that matter. All they did is that they charged me for what they didn't do to trigger the criminal usury clause. That's the point.
So much,
that's
Mr.
the nature
Koploff.
of the case. Thank you so much.
Thank you very much. Have a good day. The next case for argument is People v. Zuniga. People v. Zuniga?
Yes, Your Honor. Can you hear me?
Yes. And I can see you too.
Oh, fantastic. Zoe Root on behalf of the appellant Loran Zuniga. May it please the court. I will be focusing first on the violation of the right to counsel and second on the matter of the lesser included offense. The court violated Mr. Zuniga's right to counsel by prioritizing Mr. Zuniga's request to admit evidence of the search warrant over his counsel's express motion to exclude that very same evidence. This deference to Mr. Zuniga's desire opened the door not only to harmful evidence of the warrant, but also testimony suggesting that Mr. Zuniga was the target of it. This landslide of prejudicial testimony thwarted the jury's ability to render a fair verdict and violated Mr. Zuniga's right to effective assistance of counsel. Under Colville, we know that even if a defendant himself objects, the court must not defer to his wishes on strategic determinations, but instead must look to counsel's expressed preference. Yet here, the court granted Mr. Zuniga's request to permit the warrant evidence, which was in direct contradiction to defense counsel's professional judgment. We know that this was in contradiction to defense counsel's judgment because the sole evidentiary issue defense counsel raised prior to trial was a request to exclude the evidence of the search warrant. Judge Mandelbaum admitted that the only reason the search warrant evidence came in was because the defendant requested it. On page 116 of the transcript, the judge says the defendant insisted that the jury know about the search warrant. And on page 271, he goes on to say, as I said from the start of this, the reason for the search warrant, and for that matter, the existence of the search warrant, is really not a relevant consideration. I cannot guess why the defendant was so insistent that the jury hear what, in my view, was unhelpful to him, but that's where we are. The fact that the defense counsel gave voice to his client's desire does not mean that he acquiesced to his client's position. And we know that the repetitive focus on the warrant caught the attention of the jury because the only testimony they requested to be read back during deliberation was, quote, the testimony pertaining to the search warrant. The jury was misled to believe that the fact of the warrant was in and of itself an important factor to consider. If your honors have no questions about this issue, I'll turn now to the issue of the lesser included offense. The court erred in refusing to charge 7th degree possession as a lesser included offense because of the criminalist's testimony, and more specifically, her failure to explain the homogenization process created a reasonable view of the testimony that Mr. Zuniga possessed less than 500 milligrams of cocaine. The criminalist testified that she ground the contents of all 14 bags into a powder, tested one small portion, then extrapolated to determine the narcotic weight of the total powder. In order to conclude that the total weight of the narcotic substance was more than 500 milligrams, the jury needed some basis to believe that the criminalist not only ground all the contents into a single powder, but that the process she used ensured that the resulting powder was uniform in composition. The jury heard no such testimony. While the criminalist summarily claimed that her process homogenized the substance, she did not explain what homogenization is or what led her to believe she had achieved.
So I'm confused. So is it your argument that somehow her, the criminalist or the sampling method was somehow inappropriate or somehow gave an improper reading or led to an improper calculation?
Judge, we don't know enough about the criminalist process to determine whether or not she followed the scientific methods permitted by the New York State laboratory protocols. Because her testimony was so deficient, she may have homogenized the substance, she may not have. We will never know, and the jury certainly never did.
So she was presented as an expert witness, is that correct?
That is correct.
And so I'm assuming that there was a charge given by the court in terms of weighing the testimony of an expert witness, i.e. that they can make a determination as to whether they wish to accept or they wish to reject the testimony of the expert, and that the expert is given an opinion, the opinion based upon their experience, etc. But that again, it is up to the jury to make a determination as to whether they accept the findings of the expert or whether they wish to reject the findings of the expert. Is that not correct? So why would that not be sufficient? Why do we just not conclude, therefore, that the jury made a determination that they were accepting the analysis and the conclusions by the expert?
Because there is no way to know there is no way the jury could have determined without a lay juror, without some scientific background, could understand the criminalist testimony to the point that they are able to conclude that the weight of the substance was more than 500 milligrams.
And so did your expert submit evidence to the contrary?
There was no expert.
There was no expert. And
Right.
did counsel, I don't want to use the word, for want of a better word, attack or question the methods used by the criminalist, by the expert?
He did. He both attacked it through his cross-examination, and then he presented a timely request at the charging conference to include the lesser included offense of seventh-degree possession because there was so much confusing testimony and jargon presented in her testimony. There was a reasonable view that a juror could conclude that while there was cocaine presented in the substance tested, it did not meet the 500 milligram threshold. One thing that's really important to focus on in this case is this is a very unique case in that the lack of testimony explaining homogenization or whether it was achieved is particularly problematic in this case because the difference between the misdemeanor weight and the amount of cocaine possessed by Mr. Zuniga was 69 10,000ths of an ounce. So coupled with the criminalist's murky testimony regarding her methodology, this fact renders the view that the pure weight of the cocaine was less than 500 milligrams wholly reasonable.
And so, counsel, I just want to go back. Is there any case that states that we should, or that the court should look to the standard procedure for combining drugs or anything of that nature?
So this is an incredibly unique case, Judge, in that what is at question here is not, whether or not the random sampling method is one that should be followed by the court. That's well established, that we understand that the random sampling method is acceptable. But what we have here is a lack of establishment by the criminalist that she followed the random sampling method at all. She very clearly established that she was able to determine that that cocaine was present, but without explaining what the homogenization process was, and that the sample she tested was actually representative of the larger whole. There was no way for the jury to conclude that the total amount of narcotic weight was over 500 milligrams.
Thank you. You have 2 minutes in rebuttal. Yes, people?
Yes, Jonathan Cantarera for the people. Thank you, Your Honor. Just to piggyback.
Could you pick up on your adversary's arguments concerning the sampling method and the lack of clarity to the jury as to the homogenizing method?
Yes, Your Honor. Thank you. It's actually not a unique case at all, and I would direct this court to People v. Moultrie, which this court decided back in 2012. If you read the respondent's brief, the testimony is almost virtually identical. In fact, the testimony in this case is much more clear and straightforward because we have a single expert witness as opposed to two expert witnesses in the Moultrie case. And it's somewhat ironic because in the Moultrie case, one of the defense arguments was that they did not mention the word homogenized when explaining the process for determining the pure weight of cocaine. Here, defense is arguing that we mentioned, or the expert rather mentioned the term but didn't explain it. There's no requirement to explain it. It seems fairly straightforward what that meant in the context of the expert testimony. This expert has testified in these types of cases 10 times before, clearly knew how to explain these terms to a lay jury, and there's just simply no view of the evidence, let alone a reasonable view of the evidence, to say that on the one hand, the defendant clearly had cocaine, but on the other hand, it was less than the threshold at 500 milligrams, even taking into account the margin of error, which I believe was plus minus 71 or around that range. To my adversary's other point that perhaps the testimony was too esoteric or complicated, again, it was straightforward.
Well, they said, I believe the argument in the record, in the briefs, was jargon driven, that there was too much scientific jargon, which made it absolutely confusing, which, as you said, is in direct opposite to the Moultrie case, where it was argued that there was not enough in terms of the scientific data and I guess the scientific jargon as to how the sampling is conducted.
Yes, Your Honor, and just to that point, in isolation, perhaps certain terms may be unfamiliar, but certainly viewed in context and viewed along the lines of the expert witness's testimony, it was clear the procedures that took place, that she first tested one bag to confirm the presence of cocaine, then homologize the bags together, which obviously means to combine them together and extrapolate from that the aggregate weight of pure cocaine, which again, even taking into account the margin of error, could not have been less than 500 milligrams. And even when defense counsel made the argument below, the court disagreed because there seemed to have been a confusion as to what the exact figures were. So there's just simply no view of the evidence, let alone a reasonable view to conclude that a lesser included offense would have been appropriate under the circumstances of this case. And it's not just the Moultrie case. I would point this court also to People v. Johnson, which it decided in 2009, which basically stands for the proposition that you can't dissect an expert testimony to come up with something where under a certain view of the evidence, a lesser included offense might have been permissible, particularly whereas here there was only one expert witness who provided clear and concise testimony of the procedures she undertook.
And as to your adversary's arguments as to the impropriety of admission of the testimony or information as to the search warrant?
Yes, Your Honor. Well, as an initial matter, it's really two arguments. It's the right to counsel argument is the evidentiary issue. My adversary is focusing on the right to counsel argument. As an initial matter, I would just point out that that argument is not properly before this court. The record is not sufficient to reach the merits of that argument. As we note in our brief, the argument basically boils down to discussions that counsel may have had with the defense, whether they agreed to a stipulation they originally opposed and whether they ultimately agreed together to withdraw that application. The record reflects that some discussion took place, but it's not borne out what exactly was said. And in fact, since the defense never moved pursuant to CPL 44010, counsel was never afforded an opportunity to elaborate on that point. In any event, to the extent the record permits review, it clearly suggests that the defense and defendant were on the same page at all relevant times. Not only did the defense move to withdraw the initial application to provide for a stipulation rather than have the evidence come in, but when the court said, I'll do it on the consent, or I'll allow the evidence rather, on the consent of the defense and defendant, counsel didn't make any effort to distinguish himself from the defense's position. Later on, additionally, when the defense moved for a mistrial, the court stated on page 263 of the transcript, in fact, you wanted to keep the evidence, and clearly referring to counsel. And again, counsel made no effort to say, no, this is what the defense wanted, rather defendant wanted, not what I wanted. And that's not surprising that those arguments were not made because there was no disagreement. Everybody was on the same page. And so as an initial matter, the right to counsel argument is not properly before this court. He should have moved pursuant to CPL 440 to develop a record. To the extent the record permits review, it clearly reflected that the defendant and the defense were on the same page. And I would just point this court to the case my adversary cites. Colville involved in an extremely different set of circumstances in which there was a very developed record. There were multiple inquiries, and it seemed very clear that not only the defense counsel, but also the court were distinguishing what the defendant wanted to do and what defense counsel was trying to advise him to do. And in fact, I would point this court to People v. Baxter, which the defense cites in their brief in the instant case, in which in that case there was initially a disagreement, or initially the defense went one way, and eventually, after conferring with counsel, they jointly agreed to take a different course of action, and that's exactly what happened here.
Thank you, counsel. Ms. Root, you have 2 minutes in rebuttal.
So I'll begin by directly addressing the point that was just made. My adversary's claim that Mr. Zuniga and his counsel were aligned. It was very clear from the record that they, in fact, were not aligned. Defense counsel moved initially to exclude the evidence and only gave voice to his client's desire after his client expressed a desire to have the search warrant come in. The fact that he expressed his client's desire does not mean that he therefore acquiesced to his client's position. You can't read into defense counsel's failure to repeat his objection again and again. Clearly, as defense counsel pointing out a disagreement he's having with his client would only serve to alienate him from his client. So instead, what the defense attorney did here is he objected at the point he needed to, which was moving for mistrial, which is all he needed to do to preserve this claim. In addition, the issue need not be specifically preserved.
I'm sorry, he moved for mistrial on the grounds that the search warrant should not have been admitted into evidence?
That's correct. Yes, and that all of the landslide of information that came in after, so it started with the information about the search warrant, but that led to testimony from the police officer saying that he knew Mr. Zuniga's name before even meeting him, leading the jury to believe that that the police officer was aware of Mr. Zuniga's existence before.
Well, the basis for the motion for the mistrial was, I thought, in reading the record, was the police officer's testimony, and not because he, the attorney, moved to have the search warrant introduced into evidence. I think, aren't you conflating the two?
Well, the police officer's testimony never would have gotten to the point of establishing he knew Mr. Zuniga's name before meeting him had he not been permitted to testify about the search warrant. Because
no, I don't know that you can necessarily make that jump. I think it was just an error, in terms of the police officer's testimony. I don't know that you can say, but for the introduction of the search warrant, the police officer would not have made that statement. I'm sorry, Justice Wayne, did you have a question?
Judge, you're muted.
You're muted. You're still
Okay.
muted. Oh, there you go.
I'm here. So just to follow up on Justice Weber's point, the prosecutor apologized, saying, gave me the impression that she shouldn't have made that inquiry about the search warrant. And then the court gave an instruction to the jury about what happened, and then even gave further instructions later on about limiting instructions. And I didn't see anywhere where the defense counsel objected to any of those instructions. Right?
Well, so
there were two instructions given as a result of this.
So, Your Honor, your point about the prosecutor apologizing about extracting that evidence, unfortunately, that doesn't change what the jury has heard.
No question. No question. Absolutely right. But in a sense, it wasn't venal in the sense that it was in whatever it is. I take at face value what it is. But then the court gave two instructions. One saying that you have to, if I sustain an objection to a question, it's out of your mind. Take it out of your mind. And then the second limiting instruction later on about evidence that about the search warrant was only offered to establish the basis for being in the a home or apartment or the residence. That's it.
Right.
The story.
Yeah.
No objections to those. No objections to those instructions.
So unfortunately, that instruction was too little, too late. It came in after the jury had already started deliberating, and after they had already showed that they clearly took notice of the search warrant evidence that had come in. They asked specifically for readback about the search warrant.
But I'm just saying that if you're saying too little, too late, that would have been nice for defense counsel to raise an objection saying, Judge, too little, too late. Without that objection, who knows what happens, right?
Well, it's within the defense counsel's prerogative to move for mistrial and determine that that is the only.
And that was denied already. You have preserved it, but now I'm looking at this limited instruction, which is a new avenue in a sense to cut against the motion for mistrial that was made earlier when the moment occurred. And then there was a curative charge after the moment that occurred. No objection to that. So that kind of like takes away the cut of the denial of the motion for the mistrial. And now you have this limited instruction again after the fact. Jury started deliberating, asks for the transcript for this back and forth. Gave the limited instruction. No objection.
Right. The issue had already been preserved, so there was nothing more that defense counsel had to do by objecting to the limiting instruction.
Thank you, Ms. Brooke. We appreciate your argument. We have the papers. Thank you very much. Okay. I apologize. I skipped over a case, and I do apologize. Monique J. Versus Keith S.
Thank you. Good afternoon, Your Honors. And may it please the court, my name is Shanice Hinkson. from Simpson, Thatcher, and Bartlett, appearing as pro bono counsel on behalf of the respondent, Monique J. This is a case about a dedicated mother fighting to improve the life of her now 11-year-old son. After surviving multiple incidents of domestic violence and suffering through years of a tumultuous relationship with the child's father, the mother was awarded sole custody and permitted to relocate to North Carolina. The family court appropriately exercised its discretion when it entered its July 12, 2019 custody order, and this court should affirm that order for 3 reasons. First, the mother demonstrated that the January 2018 incident in which the father entered her home, attacked her.
If I may, please, this is Judge Mazzarelli. What effect will this relocation have on the father's visitation and the father's rights?
This relocation would diminish the father's relationship with the child only in a very small manner. The relationship that the father has with the child would still be meaningful because there would still be visits between the child and the father in New York or in North Carolina. In addition, the family court crafted a meticulous order that allowed for visitation on rotating holidays, allowed for very generous communications via telephone and via Skype. So the father's ultimate relationship with the child would still be meaningful and still benefit the child in all the ways that matter. Furthermore, the father had already not been consistently living with the child. The father served as a peripheral parent and had not been the primary caregiver, as the mother was the primary caregiver in this instance. The child battled with severe medical issues, and the mother administered all his medication for his epilepsy, asthma, heart anomalies, growth deficiency, and seizures. The mother has been the parent that attended all of the doctor's appointments, and the court awarding her sole custody was appropriate because of her relationship with the child and her history with the child.
The appellant father also claims in his papers that given the child's fragile medical state, it would be in the child's best interest to remain in New York. How do you respond to that?
With respect to the father's claim regarding the medical care, the mother demonstrated at trial that she researched the doctors and medical care at Duke University's Children's Hospital, and all of his specialists in New York agreed that it would be fine to transfer him to that facility. The father, although he made this claim, never demonstrated or indicated that he had a discussion with the child's doctors and there were any cautions or hesitations for this transfer. So it's clear that he had access to a top-tier medical team. Furthermore, the family court's order was appropriate because the current and existing February 2017 custody order between the parties was no longer appropriate as it was a joint custody order. Here, the mother demonstrated that the father did not want to communicate with her effectively regarding the child. Specifically, on January 18, 2018, the father entered the mother's home to discuss the child's medical treatment and, in fact, grew angry, began yelling at the mother, and refused to leave. He then pushed the mother onto a windowsill, which cut her lip open, caused bleeding, bruising, and pain, and then grabbed a box cutter, pressed it to her neck, and threatened to slit her throat, all while the child was present in the home. In addition, the mother testified to multiple arguments between the parties regarding the child's medical treatment, and it was clear joint custody was inappropriate and that the mother should have been awarded sole custody. Furthermore, with respect to the relocation petition, the court correctly granted the mother's application as the child had a far better quality of life in North Carolina. There, he would be able to have access to a great school system that would accommodate his special education needs. He again would have access to the medical team at Duke University's Children's Hospital. He would have the love and support of his maternal family. The mother had no family in New York. And given all of these circumstances, along with the fact that the mother's economic prospects in North Carolina was far better than those in New York, being that she secured employment, would serve as a live-in nanny to her sister, and in New York, she was unable to find a job that would be flexible and support her when she needed to go and take care of her son with whatever medical emergency that may arise. So the benefit of moving to North Carolina greatly outweighed the respondent and her child staying in New York.
Thank you, counsel.
Thank you, Your Honors.
Yes. And thank Mr. Katz, thank you for your pro bono work in this area. We appreciate it in this case. Thank you very much. And thank your firm as well.
Thank you, Your Honors. Have
And
a good
again,
day.
I apologize for skipping your case.
No problem.
What's that? Rossman v. Windermere Owners.
Good afternoon, Your Honors. Richard Feldman for the appellants. In light of the Court of Appeals decision in Regina Metropolitan Company versus DHCR and its progeny, which clarified the law concerning rent overcharges and the proper methodology for determining whether one exists, and if so, the proper calculation of damages, the lower court's judgment should be reversed. Especially since as recently as last month in the Fuentes versus Quick Realty case, which was decided in August of 2020, this court, citing Regina, vacated the grant of summary judgment, holding that in going beyond the 4-year look-back period, the lower court had committed reversible error. And it also it followed Regina that going beyond the 4-year look-back period of Regina applies to more than just J51 cases. In Fuentes, a case strikingly similar to the one at issue here.
I think I sat on Fuentes, if I'm not mistaken, Counselor.
I'm sorry.
I think I sat on Fuentes.
I believe you did.
Yes.
In that case, the tenant sued the landlord, claiming that he didn't demonstrate or have records to demonstrate that there was an expenditure of individual apartment improvements sufficient to deregulate the apartment. The tenant also claimed that the landlord had failed to provide the tenant with the notice required after deregulation, explaining why there was a deregulation, what the last regulated rent would be, and that it's no longer subject to rent stabilization.
Right, but isn't this a little different from Fuentes? From my recollection, I mean, in this case, we have no records. We have no inspection done post-construction, post-renovation, no inspection done. We have no photographs. I mean, isn't the record a little insufficient in terms of exactly what occurred, in terms of what renovations were alleged to have occurred in the apartment?
The answer is yes, Your Honor. The tenant's proof was an expert who didn't do any test borings of the floors or walls, who issued an opinion that he felt that the contractor, his opinion, had not done some work or had overbilled for other work. However, conspicuous by its absence was any evidence that the landlord owner knew of these deficiencies. The lower court did not find that there had been any proof of fraud. And Regina, hearkening back to, discussing the Housing Stability and Tenant Protection Act of 2009, says that prior to that time, the law prior to that time required proof of a fraud. The fact that the owner was victimized by a contractor and a subcontractor.
One count, Mr. Feldman, Justice Shulman has a question.
Right, I'm sorry. Mr. Feldman, so the point is, under Regina, the HSTPA is inapplicable.
Correct.
We don't go back 6 years. You can't rely on the 2002 legal regulated rent of $1,200 and change to be the base rent. You have to go back within the 4-year recovery period. So your position is so we really need a finding of fraud under Regina to allow the default formula to kick in.
Correct. In fact, this court in 435 Central Park West Tenant Association versus Parkfront Apartments, which was decided after Regina, actually held that for a tenant to succeed in overcharge claims, they must prove fraud. Here you don't have any knowledge of the owner landlord. There was no proof that they were aware of these excessive billings or bad acts by the contractor. In fact, the owner paid the invoices.
So stated a little differently, you can have a willful overcharge because you don't really need intent to that extent, but you may not necessarily have fraud.
Correct. And that's what Regina clarified. You must show fraud to be able, in the Fuentes case, this court said we can look back and the remedy, according to your honors, is we'll give the tenant a rent stabilized lease if you don't give that first notice after the deregulation, because the tenant should be aware at that time of what of the fact of the deregulation and the reasons behind it, because if it goes more than 4 years, you can't go back. So the remedy is to give that tenant a rent stabilized lease, but you can't go back decades and say that there's an overcharge unless you prove fraud. That's the context of Regina and the holding of Regina. It's the holding of Fuentes and it's the holding of 435 Central Park West. When you compare it to Thornton, where the owner granted a number of leases to a single tenant, that tenant then marked up at above market rent, and that same tenant then gave a number of subleases to a number of different people in the same building at the same time and exacted a profit on those. And then they went into court and had the subtenants declare that it was not their primary residence. That's the sort of fraudulent scheme that would allow a court to go back beyond the 4-year period. That's not present here, where the owner is victimized by a contractor who overbills. In this case, Mullen testified that it was the practice of the owner on occasion to go and inspect and do punch lists. If this was a scheme to defraud, why would you do punch lists? In fact, the problem for the owner in this case is that once the walls are sealed and the floors are poured and tiles are put on, there's nothing to see. There's no window of opportunity. Just like their expert, the plaintiff's expert, they didn't do test borings, nor would one expect an owner to do a test boring of a contractor's work. So in this case, there was no proof of fraud.
So the owner pays the contractor and pays the contractor a large sum of money, but there's no follow-up by that owner to determine what work was or was not done. They just give them the money and they say, go forth, do the renovations, but then there's no obligation on the owner to do anything further?
No, Your Honor, that's not the testimony in the case. The testimony of Mullen is that Mr. Bagelman, who was an owner of the Windermere at the time, would after the completion of the work, would go into the apartments to make sure that the work had been performed.
But this is Judge Mazzoli, but there was no testimony in this case that any such inspections were done.
What you had was Mullen testifying as to the practice of the owner.
I'm asking about this apartment.
There was no testimony that in this particular apartment an inspection occurred.
And how much did he spend on this apartment?
$30,000 to do a gut renovation.
And he never went to see anything, never went to see if there was really tile put on the floor or if there was paper put on the floor, nothing.
No, Your Honor. The expert acknowledged and admitted there were tiles in the kitchen, in the bathroom, and there was tiling in the kitchen.
I'm talking about the owner. The owner gives him $30,000, but doesn't, and says, I'm going to have a gut renovation for $30,000, which is impossible. But
that's what I'm saying, Judge. I've done renovation. That's not a big ticket to pay for doing the work. But again, these are rent stabilized at the time.
Counsel, this is Judge Doing. So what I'm hearing is we only have one side where the Mullins says that practice is the owner comes, but we don't have the other side, namely the owner, saying, yes, I did that. That's where you're saying that we need to have a further hearing on fraud because, by luck of the draw, your client didn't testify before the trial court, so that we don't have that testimony, right?
No, Your Honor, because
we're missing something.
The tenant had extensive discovery in this case.
Right.
They had depositions of representatives of the ownership.
Right.
It was their burden at the trial to prove the fraud. We don't have to go back now and have another hearing on that. They had their opportunity. They presented whatever testimony and whatever evidence they wanted to, and that was the end of it. And the judge did not find the existence of fraud. Did not. He just said that some of the charges were not substantiated. But again, they were missing the connection that the ownership.
I see what you're saying. Okay, I got it.
Ownership had to know and be part of a scheme.
So you're saying that,
Counsel, that there's no evidence of fraud. All there would be is just a lack of business acumen on the part of the landlord for not following up.
Just like under the rent stabilization code or the DHCR rules, you're not required to get the lowest price. This is not a governmental bid.
So the base rent would be the $1,200 one, the last.
No, the base rate is the $227.
No, but I'm saying
$2,227.
if there was no fraud, it would be the what? What would be
$2,227.
Okay, $2,227, correct. Okay.
That would be the base rent, which would be the rent 4 years prior to the commencement of the case.
Got it.
Thank you, Mr. Feldman. Your time is up. Thank you. Thank you. Who's going next?
Yes. Hi. Sorry. Good afternoon, Your Honors. My name is Mark Bogatin. I'm attorney for the respondent. Initially, everything that we just heard from my adversary, none of these arguments were presented below to the trial judge. In terms of the issue of fraud, if you look at the complaint in this case from day one, plaintiff certainly did allege that there was fraud committed by the landlord, and the fraud consisted of them saying certain improvements were done when they hadn't been done. Your Honors are correct. The landlord never testified at trial. Nobody prevented them from testifying at trial. I didn't stop them from coming in and saying, no, there's no fraud. We were hoodwinked by the contractors. I mean, yes, they didn't testify, but certainly an inference can be drawn. The reason they didn't testify was the landlord himself had no evidence to offer which would have been beneficial or helpful to his case.
So how do we draw an inference of fraud because the landlord did not testify?
Well, first of all, we know there was. First of all, I have two answers to that. One, you don't need to have a finding of fraud. Under Gerst, first, in terms of establishing whether or not the apartment was properly destabilized, under Gersten, there's no 4-year limitation. Gersten, the first apartment case, Gersten. In terms of the status, whether or not the apartment was lawfully destabilized, there's no time limitation. You go back and look at the underlying facts, and that's what the court below did. It looked at the underlying facts. Landlord said, I made improvements, and there's also no dispute that in terms of the issue of improvements, it's not my burden, it's the landlord's burden. Even when you go past 4 years, it's the landlord's burden to prove the improvements. And this is not just me speaking. They accepted that burden below. They never said to the court, hey, it's his burden. No, they accepted the burden. They acknowledged they have to prove the improvements. Now, when you get to the issue of improvements, it's a clear question of fact and credibility. They didn't even they presented one witness. Now, the expert said, I went to the apartment and they say this work was done and that work wasn't done. And the expert gave very detailed reasons. He said, look, if you look at the floor,
excuse me, counsel, this is Judge Doing.
Yes.
I have a question. I'm sorry to interrupt
Yes.
you,
No,
but I agree with everything you said. But when I read the trial court's decision, I didn't see him make a finding of fraud. I mean, everything was just not fraud. I didn't see that. I mean, I think everything you've said so far is, I think, on paper, it looks correct, but it was simple a matter of saying, the trial judge simply saying, you know what, and all this taken together amounts to fraud. And I didn't see that. I didn't see
Your
that.
Honor, Your Honor,
That's missing.
I'm sorry, Your Honor. The answer is, the case wasn't tried on the basis of fraud. The defendant didn't say there's no fraud here, and they didn't say it's my burden to establish fraud. They accepted it's a status case, whether or not under
So
Gersten
you're
they
saying
had
that
lawfully.
okay, so basically you're saying that you should get the default rate because of that.
Well, not because of that, because yes, one status.
That's what you're saying.
Yes. If I could finish, I'm sorry. They never proved the improvement, so they never proved the destabilization. Then you go under Levinson, Magano, and the other First Department cases I cite in my brief. Since there's no lawful, no registration on the base date of the lawful rent, you have to go to the default formula.
That goes to willfulness, though. But that goes to, as Justice Shulman said earlier, there's a distinction between willfulness and fraud. I mean, if you put the two together, boy, but we're going to have a lot of cases on fraud because so many arguments are made on willfulness, but it's not fraud. It's two different. I think they're two different animals.
To answer Your Honor's question, there's plenty of evidence of fraud on this record. We know that the new owner.
You may have plenty of evidence on fraud on this record. You may. I'm going to stress the word may. The trial court never made that finding, though. Never came down and said you got fraud here.
That's what the defendant never raised the issue. They accepted the burden that if we establish whether they have to establish the improvements. We don't have to establish anything. They have to establish the improvements.
Counsel, if you're going to ask for the default rate, I believe that it's your burden to prove that you're entitled to the default rate. You don't shift the burden to the owner and say, you got to show that I'm not entitled to the default rate.
We're entitled
you're getting the owner to pay you. It's not the tenant to pay the owner.
Your Honor, your court has already ruled in two prior cases, the Smoke case and the Chakowski case, against this landlord that the default rate applies. And those Smoke and Chakowski was the same thing. They didn't prove the improvements. The improvements weren't proven. It was beyond the 4 years. And this court, your court, ruled we get the default rate. And under Levinson, Magano, and the other cases, once you show there's improper destabilization outside the 4 years, you get the default rate. That's the law.
Mr. Bogotan, I'm sorry. Yes? This is Judge Shulman.
Yes.
Those other cases, Smoke and the others, do they predate Regina?
They predate Regina. Regina doesn't change the law.
Counsel, just give me a second. They predate Regina. Yes. And Regina, in trying to understand or deal with what is being advanced as the equity, so to speak, of trying to determine what would be the legal regulated rate under certain circumstances, Regina made it very clear that you only resort to the default formula if there had been a finding of fraud. Now, we have many, many cases that have come to our courts where tenants are claiming overcharge. An overcharge can be viewed by a tenant as a kind of fraud. In this case, your client is claiming that I was overcharged because I was wrongfully deregulated. What happened back then? 2002, the landlord had a base rent of $1,200 a month and change. He then did certain work in the apartment. He then added the vacancy allowance, the guideline increase, possibly a long-range vacancy allowance if there was a long-term tenant there. Then factored in 1/40th of the cost of the $31,000 to close this arguable gap that you in your papers say he went over by $493. So now the issue is did he satisfy whether all the IAIs were done? And you, unlike in De Lorenzo, you got an expert. And unlike De Lorenzo that relied on similar type contracts for the electric and the plumbing and for the other work being done by Mr. Mullen's company, your expert came along and gave what was viewed as a qualitative assessment. Oh, I think they overpaid on the work, or I think certain work was not done. And in one case, he found the fees were reasonable with the electricity, but it wasn't a total rewiring. It was only partial. He did that kind of analysis. So the court weighed all that and determined, well, since I determined that he didn't meet his burden, the landlord didn't satisfy his proof on the IAIs, then the apartment was wrongfully deregulated. So now, okay, we find that there's been an overcharge. And then the judge resorted to the default formula. But in doing all that, as Judge Young pointed, the judge didn't say, oh, a fraud was done here. The judge said he didn't meet his burden. The apartment was not deregulated. Therefore, I have to give him a regulated rent, and I'm going to use the default formula. The question is was it appropriate under these circumstances to do so on this record, post-Regina, not on the record that was in Smoke or in Chikaski?
Your Honor, Levinson and Magano, the other First Department, and the other First Department cases were not overruled by Regina. That was not at issue there. Under this court's holding, its law, once there's under Gersten, there's a finding that there's been an improper destabilization, and if that occurred prior to the 4-year period, you can't go to the rent history itself because you can't go past 4 years because there's no registered rent on the base date. So the only way to do it is the default formula. And it was never the issue in front of Regina. Regina was totally different. And also, if you want to look at the HSTPA, the purpose of the act is not to give a tougher burden to the plaintiff, rather to the tenant. It's to discourage dishonest landlords. And in this case, in terms of evidence of fraud, we know from 9 prior cases that the landlord had a history of illegal destabilization in the building, of inflating improvements. And we know from 3 cases that they had a deliberate policy, an actual policy to destabilize illegally every apartment they could get their hands on. So it's not a question of an innocent landlord somehow falling to getting hit with a draconian penalty. You'll have a dishonest landlord getting hit with a penalty designed to discourage dishonest landlords.
Thank you, Counselor. Do any of my colleagues have any additional questions?
No, thank you.
Thank you very much. Thank you, Counselor. Thank you.
Thank you, Your Honor.
The next case up is People v. Derek Smith.
Yes, Your Honor. Good afternoon, and may it please the court. Alma Gonzalez for appellant Mr. Smith, and if I could just reserve 1 minute of my time for rebuttal, Your Honor.
Yes.
Thank you. The circumstances of this case did not warrant a sentence that was 2 times the minimum allowable. Mr. Smith has no prior history of violence. Instead, his past is consumed by drug offenses stemming from an addiction he's had since he was a young man. And at the time of his arrest for this offense, he had actually been working for years to rehabilitate himself.
And I'm sorry, Counsel, what was this offense?
Sorry?
What was this offense?
Manslaughter in the 1st degree, Your Honor.
So he shot someone and killed them, caused their death?
Yes, Your Honor.
Okay. I just wanted to be clear.
Yes, and we're not disputing this.
Excuse me, this is Judge Mazzarelli. That was the plea bargain. That's not what he was indicted for. He was indicted for murder in the 2nd degree.
Correct, Your Honor, yes. And however, this court does have the power to.
And Counsel, I had one thing to add. This is Judge Owing. The Man 1 cases that you cite to, right? They had 14 years and 15 years. Your client got 16 years. So it's not like, it's pretty close to what the other Man 1s were getting. 1st degree manslaughter. It's not like he got more than the range as I see it. Correct?
That's correct, Your Honor, but I do propose that in comparing the circumstances of this case with the circumstances of the cases that Your Honor is referring to, the circumstances of those cases were much more egregious than the ones that we have here. I mean, even looking at Suarez, that's a case where the defendant in that case used a 2x4, used a knife, shot the victim.
Excuse me, counsel. There's no allegation here that this wasn't self-defense. There was a fight, physical fight, and there was a gun pulled, and the decedent was shot dead. He didn't have a weapon. He didn't threaten the man's life. That's not egregious?
That is egregious, Your Honor, and we're not arguing that there aren't aggravating circumstances in this case. What we're saying is that they don't rise to the level of the facts in the other 1st-degree manslaughter cases, where the defendants, as Justice Owing mentioned, got a similar sentence, and also, this case is different considering Mr. Smith's own circumstances. And just going back to the merits of that, Mr. Smith has suffered with addiction since he was 22 years old. He also is dyslexic and struggles with reading and reading comprehension. And despite all of that, he got his GED. He did attend college.
But Counselor, the person who he killed was only 26 years old. The testimony from the victim impact statements from his family are very compelling. I mean, he didn't do anything that warranted being shot to death.
And I agree, Your Honor. I'm not disputing that. I don't think that there's any justification for this offense. But even in addition to that, this court does still have the power and the authority to review the sentences, taking into consideration.
What's wrong with the appeal waiver? Why isn't it valid? Because under Thomas, under People versus Thomas, a recent Court of Appeals case, a written waiver really takes a lot out of the colloquy that goes on in an appeal in a waiver discussion. So why isn't this waiver valid? I mean, it's pretty on all fours with Thomas.
So the validity of the appeal waiver in this case, Your Honor, really hinges actually on the oral colloquy, and that's because
That's what People versus Thomas says. It's not always based on just the oral colloquy alone. You look at also the written answer. You take it as a whole. It's a holistic approach, right?
Yes, Your Honor, exactly. You do take it as a whole, and in this case, Mr. Smith is dyslexic, and so the written appeal waiver, while it was there, yes, it was
that
more
made known to the court. That dyslexic comment that you just made, was that made known to the court? Did anybody know about that? Because I didn't read about that, unless I missed something.
The plea court wasn't aware of that. The sentencing court was, but I don't think that that's particularly relevant to Mr. Smith's
You raised
understanding.
it. That's why. I mean, you're raising that point. That's why it perked my ears.
I understand that, and I'm raising that because it goes to Mr. Smith's understanding of the appeal waiver, which is the issue when we're evaluating the validity of appeal waivers. And so because he is dyslexic, it did make the oral colloquy here particularly important.
Didn't I read that he had obtained his GED and that also he was taking classes or something at Touro College?
Correct, Your Honor, and that's despite even at the time of his sentencing, he was still, struggling with reading and reading comprehension. And so the fact that he did attend college and got his GED doesn't negate the fact that he is dyslexic. I mean, he was diagnosed.
No, it doesn't negate that fact, but doesn't it go to his knowledge or his ability to understand the plea waiver and also the statements that were made to him? Not to mention the fact that he also was represented by counsel who, there was no statement made during the plea or the waiver that because of his dyslexia or because of any learning disability or that there was an issue with his understanding the plea waiver.
If we're going to his understanding of the written waiver, at least, Your Honor, the written waiver in this case wouldn't have cured the defects in the colloquy because, one, we don't even know whether Mr. Smith actually read the written form, and we
That's
also
a 440 motion.
Right?
You're going down the path of a 440 motion then, ineffective assistance of counsel. That's what it sounds like to me.
But didn't he sign the waiver?
He did sign the waiver, Your Honor.
So this is another situation where people read things, but they don't, and sign it without reading or understanding.
Yes, but I do think that it goes even beyond that because the signing and the timing of the signing is actually another issue in this case because we should have had a record of when Mr. Smith even signed this because in the written waiver form it says that that he signed that after the court had explained his appellate rights and a host of other points, and we don't even know when Mr. Smith actually signed it in the course of the colloquy. And
I don't know that was even on appeal or in the record, but my understanding from experience is that the waiver is given to the defendant, it's read by the defendant, then there's an oral colloquy, and then the defendant signs it. I recognize perhaps this record doesn't say the record should reflect the defendant signing the waiver in open court, but I didn't see anything in the record concerning any issue as to whether he signed or when he actually signed the waiver. But counsel, you have you asked for time on rebuttal?
Yes, Your Honor.
Yes. So, Ms. Is that Namian?
Yes, Morgan Namian May it please the court, I am here for the people, and I am arguing under the supervision of ADA Nancy Killian. Your Honors, here, defendant validly waived his right to appeal, and regardless, his sentence was entirely proper given the fact that he admitted to shooting and killing a 26-year-old college graduate who had a wife and a child on the way.
So on the man one, he pled guilty to manslaughter in the first degree, yes?
Yes.
The minimum was 8?
Sorry, what was that?
The minimum on the man one was 8 years?
Yes, 8 to 25 years is the
and so he was sentenced
range.
to 16. So as your adversary stated, he was given 2 times or twice the minimum.
Correct. Or you could look at it as less than half of the permissible sentencing range or the permissible maximum. Regardless of where in that range it fell, it did fall within the range of manslaughter or the permissible sentencing range. I'd also like to point out, which was brought up a little bit in my adversary's argument, the fact that he was initially indicted for murder in the 2nd degree, which he could have faced a sentence of 25 years to life. And that's not to mention the fact that he could have faced consecutive sentences based on the fact that he had this gun and possessed it prior to using it to kill the victim in this case. Furthermore, insofar as my adversary argues that defendant has made all these extraordinary efforts at rehabilitation, my job isn't to sit here and say whether or not those are extraordinary, but what I do know is that all of those things were properly before the sentencing court prior to the sentence in this case. So in effect, nothing that defendant alleges now as an unusual or extraordinary circumstance that would warrant a further reduction, none of this is new.
What's your comment about the appeal waiver, counsel? This is Judge Join. Your commentary about the appeal waiver. She's arguing that the waiver is invalid because he had a condition. He's dyslexic. He couldn't read. I mean, it is what it is. But what's your response to that?
Well, so I think you're correct to point it back to the totality of the circumstances consideration or analysis in this case. I mean, if you look at the record, even before the court brought up the appeal waiver, the court reminded defendant that, if you don't understand, feel free to ask your court or attorney. And we know that defendant understood that he was allowed to do that because he did, in fact, ask for clarification later on the record. Moreover, speaking specifically to the court's language, they said that the appeal right was separate and apart, given that the people were not moving forward with the murder charge. In other words, saying that, the people are going forward or they're not going forward with the murder charge, given that they, offered a plea to that manslaughter charge. Furthermore, the colloquy itself, the oral colloquy, the court did specify that defendant would be waiving certain rights and other rights would remain. Finally, when it came time to actually talk about the waiver, the court made sure that the defendant had discussed this waiver, the appeal waiver, with his attorney. Defendant said that he understood it. He agreed that he understood the explanation of the right to appeal and the appeal waiver. And then they verified that the signature was on the waiver on the record, so it's unclear, right, where or when he signed it, but he did confirm the defendant confirmed on the record that was his signature there. So again, it's like if we're looking at the totality of the circumstances, we have a lot of court language and we have a lot of defendants confirmation that he understood kind of throughout the entire colloquy. Sorry, one moment. Furthermore, I would like to just address the point about dyslexia. Again, not only was that in the PSR and was properly before the sentencing court, but also it's sort of an interesting argument when I think, as you're getting at in my adversary's discussion, the fact that we have a defendant who has some difficulty or has some past difficulty with, understanding and reading. Okay, so now we have a court knowing that fact, or not exactly knowing that fact, but using language that is not legal jargon. It's not inaccessible. In fact, it's, I think, deliberately tailored to speak to the defendant that was in the room on that day to make sure that, is what I'm saying getting across to the defendant. And I think pretty much across the board, the record shows that the judge was constantly checking in to make sure that the defendant understood. Defendant was confirming that he understood, and that that I think that there is enough in the record to show that defendant did knowingly and intelligently and voluntarily waive his right to appeal in this case.
Thank you, Ms. Damon. Ms. Gonzalez, did you reserve time? Rebuttal?
Yes, 1 minute, Your Honor.
Yes.
So I'd just like to point out to the court that first, the colloquy with respect to the appeal waiver was very short. In fact, it only spans about a page and a half. And when getting at the point about the oral colloquy with separate and apart language that my adversary was pointing out, that really is the main defect in the colloquy here, in that the court didn't adequately explain that the right to appeal is separate and distinct from those rights automatically forfeited upon a guilty plea. And when the court explained the waiver, it told Mr. Smith, quote, "In exchange for this plea, separate and apart, you are waiving your right to appeal." However, the problem is that it stopped at separate and apart without saying what the waiver was separate and apart from. And so from that record, there's no way of assuring that Mr. Smith actually recognized the distinction between an automatic forfeiture and a waiver. And
how is that different from Thomas?
So that's different from the waiver in Thomas, Your Honor, because in Thomas, the main issue was really the written appeal waiver. And here there's also defects with the written appeal waiver. The court in that case did validate the waiver because of the oral colloquy in this case, but the circumstances of Thomas are different than the circumstances here when Mr. Smith was dyslexic in this case. It really did hinge on the oral colloquy, and the oral colloquy here wasn't in itself defective. And because of that separate and apart language, Mr. Smith didn't know that there was a difference between an automatic forfeiture and a waiver in this case.
Thank you, Counselor. Thank you very much. Your time is up.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Last but not least, Victor Media versus Go New York. And you guys are very lucky because it's a non-denominated order and you should not have been granted any time. So count your blessings.
Well, thank you, Your Honors. Good afternoon. My name is Maurice Ross from Barton LLP. I represent Go New York Tours. This is an appeal from a preliminary injunction granted by Judge Barak. This case involves, as far as I'm concerned, only money. And the issue is whether there was any basis for Judge Barak to transform a case that involves money into a preliminary injunction. I'd like to focus today on the issue of irreparable harm.
Well, counsel, I have to ask you a question. When you say it's just about money, the way I understand it is the plaintiff here puts ads on your buses, correct?
Correct.
I mean, this is great because I see the buses going through town or through this town all the time, and I see all these ads. Now I know how this is done. He puts ads on your buses, but he gets the business from other people. It's not his ads. It's he goes out, he gets people to get him to put their ads on your buses. So he's sort of the go-between, correct?
Correct. And he puts ads not only on our buses, but he puts ads on all of the buses.
Let's put that aside. This is only about you. We're not talking about the other buses at the moment, or the other companies at the moment. He's talking about just your. Let's just focus on this for 1 minute, okay?
Okay.
So he's putting ads on your buses, and he's saying that the irreparable harm comes into play is when he can't get those ads on your buses, or somehow the ads don't, or defaced or destroyed or whatever. he's going to lose his business from the other side because people are not going to go to him to advertise because they're going to say, you know, you're not making it, and he's going to lose that business, and that's sort of a goodwill situation, right? Don't you think that's goodwill there? That's sort of like a reputation. Oh, go to this guy because he's going to get your ads on the bus, and you're going to get a lot of business from those ads, right? So,
Your Honor, that would be true, except that that's not what the record here shows. What we have here, and Your Honor wanted to only focus on my client's buses, but it's really important to understand the competitor buses. This is a case involving 3 competitors who run these buses.
right,
Rayline, Go New York,
right,
and Big Bus.
right.
They all carry the same advertisements. Vector has an exclusive contract with all of them. What happened in this case is my client believed that it was being screwed, excuse my French, out of millions of dollars by Vector.
Well, that's why your client wanted the surcharge. He wanted to surcharge the plaintiff another $1,500 a month.
That's
outside
right.
Of the outside
That's
of the contract. And the guy said, okay, fine. You know what? I'll do it this time for an accommodation. Not changing, according to Justice Borak, not changing the terms of the agreement, right?
But Your Honor, that was the tip of the iceberg. The real fundamental problem was my client thought it was being cheated out of millions of dollars. It terminated the agreement. And then what happened is, now what, and the problem here,
Wait a
Your
minute,
Honor.
wait a minute. Hold on a second. You're saying your client believed that they were being cheated out of millions of dollars. They went into the contract with the formula in place as to how much your client was going to get paid on a monthly basis. If that turned out to be a bad deal, that's not getting cheated out. That's just called getting a bad deal, not doing your due diligence, because and the length of the contract that your client entered was a 10-year contract or something. I forget how many years, but if your client was going into the contract and said, you know what, I'm going to not get into your contract for maybe more than 1 year or 2, not a long-term contract, especially if you knew there were 2 other competitors out there.
Respectfully, Your Honor.
Commercial case, come on.
Respectfully, Your Honor, it was not being cheated because of the length of the contract or the amounts that were supposed to be paid. It was being cheated because they refused to provide an accounting of the amounts due. And the numbers that were paid didn't add up with the extent of the advertising on my client's buses.
So then that's a breach of contract claim you have against the plaintiff then, right?
That's exactly right. And what happened in this case is the irreparable harm that is alleged is the loss of advertising space. But 2 things happened. My client said, look, we will take the ads off of our buses, number 1. Number 2, you can put the same ads on the buses of your competitors. There's no dispute in this record.
But by saying that, what right does your client have to tell the plaintiff, I'm not going to have you put ads on my buses. You can put those same ads on the other 2 competitive lines. Because you have to say that.
Because the bus advertising is interchangeable, and my client had the right to say that.
That's your position, but you got a contract here that says that they can advertise on your bus.
But Your Honor,
excuse me. I'm sorry. 1 second, counsel. Justice Mazzarelli has a question.
Yes, I'm confused about your argument regarding irreparable injury, because in the contract, the parties explicitly agreed that such a breach or a threatened breach would constitute irreparable injury. You made that agreement.
Well, First Department
so how can you now argue it's not irreparable injury?
Your Honor, under First Department case law, a boilerplate provision like that is not definitive.
Please, that is not a boilerplate provision in any sense of the word. Not in any sense of the word. I will assume, and I think I am correct, that both parties here were represented by counsel. Both parties are sophisticated business people. And this is not the kind of thing that's boilerplate at all. Boilerplate is you have to mail something to somebody by a particular time or a particular location. Maybe I would agree that's a boilerplate. But something as sophisticated as explicitly agreeing that a breach or a threatened breach constitutes irreparable injury is far from boilerplate, only speaking for myself.
Well, Your Honor, your statement included an assumption that was not true, which was my client was sophisticated. At the time of this agreement, my client ran 3 buses. He had no lawyer at the time he negotiated this agreement. He signed this. He barely speaks English even now. And so it's not true that my client was sophisticated. We do think this was boilerplate, and we think, more importantly, the law in this department indicates that a provision like this is not determinative. It's a factor that the court may consider, but it's not the only factor. I want to come back to irreparable harm on the bus.
Well, this is not a final determination. This is a determination on a motion that's in the course of the litigation. This doesn't finally determine the litigation. And I think your client's probably very sophisticated. I don't even have 1 bus.
Well, Your Honor, respectfully, we think this is an extraordinary injunction that went beyond the normal preliminary injunction. It didn't just maintain the status quo. It forces my client to continue to work with Vector Media against its will. These people do not have an amicable relationship. The question that the court has to consider is there really irreparable harm here?
How does it force your
advertising space?
I don't understand how it forces your client to continue to work with them.
Because our client has to deliver buses at a specific time and place every night, if requested, and allow them to place advertising on the buses. And my client is precluded from doing anything other than that under this injunction. And what's really interesting is, despite the court's intent to maintain the status quo, Vector has found ways not to even continue paying the monthly minimum that is due to my client. On the irreparable harm issue, this Court of Appeals has held in the Van Wagner advertising case that the loss of a relatively unique advertising opportunity may still be compensable by money damages, and that involved billboards. But this is very similar. And what they're saying is their reputation might be harmed because if they don't have all this inventory, they won't have enough inventory to place the ads. But there's nothing in the record to support that. They didn't provide any agreements with their advertisers. They didn't provide any information as to whether those advertisements could be placed on the other buses that are running in the market. In fact, only half of the advertising on these other buses is being used. There's no reason why they couldn't have switched the advertising from Go New York Tours, put it in these other buses. If they want to assess us the cost of doing that, and we fight about that in court, it's all money. But there's no reason why this advertising opportunity that they claim was lost could not be compensated by money. You don't issue an injunction in a case like this, respectfully.
Thank you, Mr. Ross. Mr. Katz?
Thank you, Your Honor. Brian Katz for the respondent, Vector Media. Your Honor, we submit that the decision by the IS court below was in all respects proper. As an initial matter, I know Your Honors are well familiar with the standard for basically vacating a preliminary injunction on appeal. It's abuse of discretion. We all agree on that.
Counsel,
it has to be
let me stop you. I'm sorry. This is Judge Joring. I want to get right to the heart of it. He's saying that you don't have irreparable harm because you can put your ads on the other 2 bus lines, that you don't have to have my bus line, and that what the court did with this preliminary injunction is to keep a marriage when the marriage is already broken. How do you respond to that?
Your Honor, this is a long-term relationship even before it was extended. We need this space. Vector Media needs this space. It's a unique bargain for opportunity, and it has to have that demand. As Your Honor appreciates, particularly in present times, demand ebbs and flows. And Vector Media has identified this company and this company's space to advertise on. As Your Honor pointed out, the fact that we have other arrangements is irrelevant to this particular contract.
And that's just savvy on your part that you gobbled up all the ad spaces.
I would say, Your Honor, not only I would agree, but not only that, Your Honor, a loss of this type of market share in and of itself is irreparable harm. In and of itself. With respect to irreparable harm, the IS court identified at least 4 independent bases for a showing of irreparable harm. And to point out again that the defendant agreed. The appellant agreed not only that it would constitute irreparable harm and that we'd be entitled to an injunction, but that monetary damages would be inadequate. and that they wouldn't be easily ascertainable. Now, everybody knows that's true. How do you determine how a client who advertises in multiple cities is affected by having stale advertising that's missing copy running around the streets of New York for people like Disney, as is evidenced in the record? That's a big problem, Your Honor. That's a loss of goodwill. We can't easily value that. And the loss of reputation is significant because it means to these very important brands, well, Vector Media can't deliver. They say they can deliver, but look out on the street. They can't deliver. That's a big problem. How do we quantify that, Your Honor? Not an easy thing to do. So we have all those features of irreparable harm.
You just made a very interesting point. There could be a scenario, as outrageous as it could be, is that you do sort of cave in and give in and say, okay, fine, you know what, we won't advertise on the defendant's buses anymore. We'll just limit ourselves to the other bus lines. As crazy as it could be, the other bus lines could come after you saying, no, we entered into an agreement with you knowing full well you had 3 lines to advertise on, and now you don't have only us 2. And now we got a problem with that because their advertising is better than yours. And, you know, and then the next thing you know, you're caught in a big mess.
It's exactly right, Your Honor. That's another reason why this individual right that Vector has with the appellant is a unique right. It's akin to a unique piece of real estate. The Van Wagner case that my adversary cites has nothing to do with this. That's a billboard. A billboard is very different than a tour bus exterior going to specific high tourist density locations to attract consumers, which, as Your Honors all know, that's what advertising is really all about here. And at the end of the day, I would say that when the appellant has agreed to something, it should be held to that agreement. That is all that is happening here. One really instructive point I might add, this injunction is not an unprecedented injunction. This injunction is a very narrowly tailored, discrete injunction. All it requires is access to 1 vehicle at a time on 72 hours notice for a copy to be installed from 11 p.m. to 5 a.m. Our guys have to work in the middle of the night just to make sure that their core business is not impacted. Their core business is running tours. This is the lightest touch that a judge can possibly enter into. And for that reason, it comes nowhere near the extraordinary showing that is required to vacate a preliminary injunction. There is no abuse of discretion here, as Your Honor knows. If Your Honors have no further questions, we think it's very clear they don't contest the likelihood of success on the merits, just gone through the balance of the equities. And I think I've identified at least 4 ways in which irreparable harm is clearly found here. The IS court's decision should be affirmed. Thank you, Your Honors.
Thank you. Does anyone have any further questions? No? Thank you very much, counsel. This concludes our arguments for today. Court is adjourned. Thank you.
Thank you, Your Honors.